for fairly obvious reasons. Some of these appeals are going to be very brief. They involve residential property or simple issues, and two of the cases are fairly complicated. And we don't want to have everybody sitting through hours and hours of testimony and discussion when maybe their case is a 15 or 20-minute case. So we're going to go out of order a bit. And I also want to say that we're going to limit this meeting to 11:30 p.m. We're going to call this meeting over at 11:30 regardless, and if we have to, we'll continue whatever case is still pending that hasn't been completed. The one other thing I want to mention is the sixth item, as the agenda was published, appeal number 2918, 400 Orchard Way. I want to disclose that I am a neighbor of that property. I live 2 doors away from it. I can't see it from my house because of the way the other house is oriented in the hill. I do not know the owners, don't feel good or bad about them, I'm totally neutral. I do not intend to recuse myself, but because I'm within my property is within the required area for notice, the radius, I did get a notice as a homeowner, so I want people to know that I would have standing to appear in this matter as a property owner, and if I intended to, I would recuse myself, but I don't intend to. I have no position that would influence my decision one way or the other until I hear the case. If anybody objects to that, speak now or forever hold your peace. Okay. We have been advised by the appellant in 2919 406 Woodland Avenue, Mr. Babin, are you here, sir?
Yes.
That a continuance is being requested. I believe there's 2 reasons. First being that the notice was not sent out in a timely fashion. Yes, you could step up. And the second is, I believe you requested specifically a special exception to a section of the code that does not authorize us to grant special exceptions, so what you really wanted to ask for is a variance.
Correct.
So I think we want to get that on the record.
That's correct. I sent a letter today requesting that with the exception, if I can modify the wording in the application to replace, to insert variance rather than a relief from the ordinance.
Well, I believe the advertisement text said relief, which is not incorrect. That would apply whether it was a special exception or a variance. But I think you should probably modify your application to say variance, because that's what you're asking us to do. And since we can't do that, you're going to be doomed before you start unless you correct that on the record. So I guess for now you are saying that you should change the actual application. John, don't you think you should?
Just to, give you the benefit. Perhaps he might say variance or other relief. That way you've got your backstop. We know it's a variance. You know it's a variance case, and that's clear. And the publication notice would be, very tight and properly done.
Okay, I was going to go to the Township building tomorrow and make that revision. So where my architect initially filled out the application, I had not seen it till I spoke to Mr. Ryan. So in the opening paragraph it says relief from Radnor zoning ordinance section blah, blah, blah. I'm going to say variance or other
applicable relief.
Applicable relief to same ordinance number.
Precisely.
Okay.
As long as we know what hardship you want relief from, what kind of relief you want, we need to call it a variance.
Yes.
It's more than just a technical issue, because the burdens of proof are different, the burdens of coming forward with evidence are different, and
Okay.
in fact, we have no authority unless the code section specifically says this can be done by special exception.
Variance or other relief.
Yeah.
Okay.
Okay, so now you're granting the appropriate extensions of time?
Yeah, you're
Yes.
extending till the 60-day period through the July hearing, and also we have 45 days after the closure of hearings, and that would be extended by this delay as well, so that
Okay.
everything gets pushed back.
Yes.
Is that acceptable to you?
Yes.
I believe, John, that the application that was filled out, and it's always filled out, says that there is, I think, a $150 fee for a continuance. So you should be
I
aware.
think it was 200.
Whatever it is, you should be aware that you may
yes,
have to make a
I did.
payment.
I gave the
Okay,
check
okay.
yesterday to the Township.
Okay. Very good. Then you're continued till the July meeting.
Thank you.
That's
We'll see you in
July
July.
17th.
Thank you.
Sir, your full name, your name. Excuse me. Oh, sorry.
Okay, the next case we'd like to take, because it should be fairly short, is appeal number 2918, 400 Orchard Way. The applicant, William J. Kyle, property located at 400 Orchard Way and zoned R2, seeks relief from Section 28022, accessory structures of the zoning code, to construct a roof over walkway from garage to house to serve as a breezeway.
Good evening.
Shall I swear the witnesses in?
Are there witnesses? Could you identify yourselves for us? We know.
I'm William Kyle, WJK Associates.
Hello, neighbor. Glad to meet you.
How are you? He's the neighbor.
I'm your neighbor.
He's the neighbor.
Oh,
James Meehan.
oh, okay, Mr. Meehan. Well, you may as well, are you both going to be witnesses? Or-
Yes.
Well, you may as well swear them in.
If you both raise your right hand. You do solemnly swear or affirm this testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes.
And your names once again, and please spell them.
William J. Kyle, WILLIAM,
James Meehan, Janes, Meehan.
Now, Mr. Kyle, you're,
No, I'm not. I'm not, just a designer, architectural designer.
you prepared these plans?
Yes, I did.
I wasn't on, sorry.
That's okay.
I have a couple of questions before you get started, just so we can clarify some facts. Things that I didn't catch on the plans, and maybe I just missed them. But one of the things that's important in a case with this subject matter is knowing what yards we're talking about. So for instance, because this is a corner property, under our code, there are 2 front yards. Because of that, there's only 1 side yard, and there's 1 rear yard. Now, where this garage is located vis-à-vis those yards, and what we call the building envelope informally, is important in deciding certain things under the code section that's involved. I didn't see anywhere where we've shown the distance from, for instance, the back corner of the garage at its closest point to the rear line. It doesn't show what the distance is.
About 10 feet.
Is it 10 feet?
10 feet.
Exactly?
Yeah.
Okay. And it doesn't show the distance from the street right-of-way to the closest, I'm talking about now the St. David's Road street right-of-way, to the closest corner of the garage. Do we know what that distance is?
I'd say that's about 40 feet.
I'm sorry?
It's about 40 feet.
About?
I'd say about 40 feet. Off the top of my head, I don't know.
Okay. Because we have to decide, is this garage located in a front yard, a side yard, a rear yard? It looks to me like it's probably located in a rear yard and possibly in the front yard. Now, if it's 40 feet, then it's not in the front yard.
No, it's.
It actually has implications under the code section.
I believe if you look closely at the drawings, there's a dashed line which represents the setback line. It may not have been dimensioned, but it's articulated in the drawing.
Okay, but of course, in the rear yard, if it's an accessory building and not attached to the residence, it can get as close as 10 feet.
Correct.
Yeah. So it's definitely in the rear yard
That's
then?
correct, yes.
Okay. But it looks like that if what you're saying is so, and I guess it is, then it's it's not in the front yard,
No.
either front yard?
No.
And it's not in the one side yard?
Correct.
Okay. Thank you for clarifying that.
Not a problem.
So can you speak in the mic?
Yes, I'm sorry. Yes.
If you need one of these, we have a radio
This will be fine.
in case you both need to say things at the same time.
All right.
No harm, I'll put it on.
Mr. Chairman, at a time of your convenience, we probably go to label exhibits. And I'm also I understand lines are put there, but without the dimensions, it's hard to administer, the plans like this.
Well, I guess we're going to have testimony that says, well, he's a witness. He's saying that those lines on the plan were put at the yard limits, so the building envelope is shown on there. we don't really need to know whether it's 10 feet or 11 feet from the rear line. We need to know that it's no closer than 10 feet, but that it is closer than the building envelope line would allow it to otherwise be. And we don't need to know if it's in the, how close to the front yard it is, as long as it's out of the front yard. So I think with that testimony, we've established the building envelope and the things we need to know. Do you think there's more that we need?
I think there's also the concern for future cases, and I think the testimony would be adequate. But in the future, I think that we've had this issue come up before. Plans need dimensions on them.
Well, just to clarify, the house was built back about 22 years ago, and the garage. So, that was at that time, the house was built in conformance with the code and setback requirements.
Yeah, but I'm not sure those are the same requirements that are here. All I'm saying
Yeah,
is
it's a
the
different
plan
issue,
should be on
yeah.
its own four corners, have every distance that we, need to be able to evaluate. Because one thing this board has to do is to evaluate with certainty what, if anything, it's going to authorize. It can't say, well, we're kind of happy with a building sort of in that part of the lot, but it has to. We need the precision on that.
Okay.
But, Mr. Chairman, that's, you're...
You see, there is a point I want to make, John. You can tell me if you think this is adequate. Normally, if they were asking for relief to go closer than would normally be allowed to a yard line or a sideline, we would, of course, need to have dimensions to say we're letting them go within 7 feet or 6 feet or 5 feet. But in this case, my only concern was because of the wording of the section we're talking about, there are different consequences if the accessory building is located in this yard or in that yard or within the building envelope. So we just need to know that fact, and we don't really need to know whether it's 10 or 12 feet for this purpose from the rear line.
I
Yeah.
agree with
I mean, if you think we're not able to reach a conclusion, a legal conclusion on the
You're
case.
you're connecting two buildings that are there with a breezeway, so it's pretty clear, they're not moving either building, and you're just allowing a breezeway. Under certain connection with a breezeway, under circumstances like that, I agree that the need for numbers on a map is less than it would be otherwise, but I just make the observation that we do need precision in our plans, and we have routinely, where the board isn't fully comfortable that it can understand what it's doing, deferred hearings on that basis.
Well,
But
would you advise us to do that in this case?
I think it's a coin balanced on the edge. Under normal circumstances, I would. On these circumstances, I think that the board could proceed.
Mr. Chairman, your concern is that with the breezeway, the garage becomes an attached building now, as opposed to a separate building?
It actually becomes the principal residence, part of the principal residence.
And you're
under that section.
satisfied that a breezeway makes it an attached building?
Yes.
As opposed to
I
a
am, yeah.
completely covered walkway?
Well, I don't know the distinction in the code. Let's just double check the code section here.
I don't
think
think you're
I
going to
marked
get
it.
much guidance there.
Well, what it says is, this is the, for those of you in the audience here or at home, it's section 28022, accessory structures. It says accessory structures to a use permitted herein shall be located as designated hereunder. A, attached to a principal building, in which case they shall be part of the principal building. In other words, the principal building now becomes enlarged to include the entire attached set of structures. B, on the buildable area of a lot, but not attached to the principal building. Well, this is not all of the buildable area that we see from where the envelope is shown on the plan. C, in the rear yard and side yard of a lot, well, this is in the rear yard partially, in which case they shall not be located closer than 10 feet from the side or rear property line. That's not an issue because you are 10 feet from the rear line, you're saying. And then the D has to do with air conditioning units is not relevant here. So you see, what my real issue is, and we may have, since this has gotten crystallized before you even present your case, the issue is, if this becomes part of the principal building, and it's my interpretation that it does, everyone will have a chance to say if they feel otherwise, then the question is, are we now allowing you to have your principal building within 10 feet of the rear line? And could that then be used by you later on to say, well, then I can extend other parts of the building to that distance. And of course, we don't want that outcome. Nobody's going to want, and I don't think you're looking for that outcome. So this is the reason why this is important to know as a matter of fact, and we'll get to that when we get to it. But
Mr. Chairman, I don't see any way that this could be approved except by variance, and variances may not be expanded by principles of nonconformance or anything like that. A variance is what is granted, and that's all, which is why the dimensions in a variance case are of importance here. I think we ought to get testimony that that building setback, specifically, that building setback line is accurate. If we're going to proceed that way.
well, what I would say, John, is should we grant the relief they're asking for after we hear the case and have the motions and the vote, that we are not making it part of the principal building. We may allow them to do this, but without having the consequence of making that part of the principal building for any future purposes. And that way, that's never an issue, because according to this, that would automatically make it part of the principal building. So the issue isn't that they're expanding a variance we've given them, it's by giving them the variance, en passant, we're doing something else. We're creating it part of the principal building.
We could word that either, however you characterize it, all they should be able to do with any relief that you grant, the board grants, if the board grants it, is to build this breezeway. It is not a precedent for expanding the house. It's not a precedent for putting more stories on any part of it. All they may do is to put in the breezeway, and there's no, it doesn't become a non-conforming thing that is a piggyback for other projects or relief. All you would grant would be, all I see that this board could appropriately grant is a breezeway, this breezeway.
Okay, without having received that explanation from our solicitor, please proceed.
Do
Okay.
you want to label the exhibits?
Well, as they introduce them. we
Oh,
don't know.
okay,
Yeah.
fair enough. Because you need to introduce, we need to end up with all your exhibits labeled.
Okay. Well, first off, the package that I had sent via mail, I guess that would be Exhibit 1.
Well, actually, why don't we break that up if we might? Make the application A1. Okay. Then we have two sets of plans. I mean, this all came with your application.
correct.
So
Yeah.
it's all, breaking it up. We have SP1 and, let's see, SP1 and A1 and is there another A in there? A2 and A4. Why don't we make SP1 A2?
Okay.
Because that's, I understand that you have SPs and As.
That's fine.
As are appellant, L appellants.
Not a problem.
Okay. Let's make A1 A2. No, wait a second, A3.
A3.
A3. A2, A4. A4, A5. Then you have a package of materials. You have an annotated copy of a portion of SP1. Why don't we make that A6?
That's with the packet of photographs?
Yeah, oh, this is the photo plan
The
key.
photo plan, yeah.
All the photographs are part of this, except you have the deed. Why don't we do this? The photographs are all A6,
Fine.
and the deed would be A7. And that disposes of the exhibits that you sent in the packet. If you have
Correct.
more, we'll add them on as they are
Okay.
introduced.
Okay. Then I guess we'll make this photograph here A7, the one that's on the board?
Is that in our packet?
No, it's not.
Okay.
I'm just using this as a graphics. I prepared this for our Harb Commission meeting as well, just to illustrate the type of work that we were doing.
Okay, are you going to be able to put a copy into the record? Leave a copy
I could
with us?
Get a copy of this made, or, I mean, it's not foldable. It's actually on a board.
Okay.
But I could get copies made, and I could submit them afterwards, if that's okay?
Mr. Chairman, could he submit the copies afterwards, leave the board
No,
with
that's going to be a
us?
problem, because we need to have the record complete, because if
Okay.
anybody objects to this and has standing and wants to appeal the decision, or
Well, then
you
I
wanna-
won't, then I won't use this then as an exhibit. How's that?
That's,
I
Well,
mean,
I have no problem with them wanting to illustrate something with it, it's just we can't use that as evidence.
That's
I mean,
fine.
They
I
just
just-
want to orient us to
Yeah, that's
something.
fine. It's just to give us, it's a source for using the visual aid, that's all.
But keep in mind, our concerns are not really aesthetics.
I understand
No,
that. I understand that,
Our concern is
yeah.
very
Well,
technical,
the
geometric.
primary concern that my client has is as part of their enjoyment of their life, they would like to be able to, go outside and get into the garage if they're going somewhere in the rain, inclement weather, things of that nature. It's primarily a source of, allowing them to do that. As they presently are, they just go out the side door and walk across an open area and then into the garage. That's the number one issue. Notwithstanding the fact that it does enhance the property and is part of a design solution. You want to add anything, Jim?
Well, I guess as Mr. Kyle had stated, it was our intent to do, as Mr. Kyle said, to have some way of getting to the garage without getting rained on or snowed on. It is a breezeway. When we were discussing this issue early on in the planning process, we looked at a number of different ways of creating a breezeway. And I guess many of the other ways, if we chose one of the other ways, we wouldn't be here before you this evening, because they could take the form of an awning or a pergola or some sort of glass that's not attached, built rooftop to rooftop. But even though it was just mentioned that you're not into aesthetics, but that would look pretty ugly. And so we designed this to continue with the roof line. We've been before the architectural or Harp Commission, and they loved what they saw. They loved the way we planned it out. And I guess as an owner of the property, if the board requests that for approval, there's some conditions on this that our intent is a breezeway and it will always be a breezeway. If there's a way that you would want us to somehow restrict the property to never going beyond that, I would be more than willing to do that.
it's just, the breezeway is indicated in which of these plans? I mean, you have the location in,
It's right here. You want to look at this graphic?
yeah, that's what, that kind of a substantially, it's similar to that, and nothing else.
Yeah. That's it.
Yeah. No, we have a,
It's on the
oh,
elevation.
we don't have, yeah, isn't, oh, it's not in evidence, because that
No, it is.
been put in.
I think if you take a look at A3, which is your original A1,
It's there. There's actually,
it somewhat describes it,
Right.
but I don't think it's
there's actually,
perhaps describing it with the specificity that we're
there's
looking
actually
for.
a note on the drawings that, in a box that points an arrow down to it, that states that,
It's shown on Exhibit A3 as new slab with pedestals, and then it's shown on A4. You see the roof there and the columns, that's the pedestals? It's shown on those, John.
Yeah, there it is.
And it's shown, the rear elevation is shown on A5. Yeah. Is there any other information you want to put in front of us and on the record?
That's all.
Any of the board members have any questions?
Mr. Chairman, I think we ought to just close the loop that the placement, testimony from the applicant that the placement of the building setback line on their map is accurate.
That is correct. It is the setback line from the corner of the garage, or from the corner of the garage to the property line is 10 feet.
So if somebody were to take the ordinance and the appropriate measuring thing, they would come up with that
That's
line.
correct. That's correct.
That way, we've got the applicant saying that the line is accurate.
And Mr. Meehan, as the property owner, you verify that that's true?
That is true, yes.
Got them both saying it. Any other questions?
Yeah, actually, I'm a little confused by that last statement. I'm looking at A2, and I think you indicated earlier that it's not a dotted line, but it's a broken line that identifies the setback. There is a portion of the existing garage that is outside the building envelope, correct?
Yes.
And the issue then becomes whether, by reason of attaching this breezeway, and I'm sure we'll talk about it, whether that turns it into part of the principal structure, principal residence. But you're saying it is 10 feet.
From
The
corner of
the nearest corner to the property line
That
is
is
10
correct.
feet.
That is correct.
Thank you.
Any other questions? Chair will entertain a motion if someone cares to make one.
Mr. Chairman, can we confirm that there's nobody else in the audience to speak to this matter?
Is anyone here appearing with regard to this matter? Want to be heard? Neighbors? I guess I'm the only one, and I don't want to be heard.
You didn't raise your hand.
I'd like to offer a motion. Mr. Chairman? Motion to authorize the relief sought to permit an attachment of the existing garage to the main dwelling in accordance with the exhibits presented to the zoning hearing board, and with confirmation that the relief shall not authorize any further addition to the main dwelling or the garage not in accordance with the township zoning code.
Is the motion seconded?
Second.
Discussion on the motion? No one else says. I have one point I'd like to discuss, and I would like to condition it upon it remaining a breezeway for as long as it's there, not to ever be enclosed.
Accepted.
It's remain as a breezeway, and that we will be very careful that we're going to, I would like the order worded to make it clear that by doing this, we are not seeking to grant principal building status to this. It will be treated as though it were not part of the principal building, notwithstanding the provision of the code that we were talking about, 22 sub A, for any other purpose. You're just being given permission to attach it, leave it where it is, and attach it with this breezeway as shown on the plans. Yeah.
Accepted. Thank you.
Anybody have any problem with that clarification? Huh?
No.
Okay. All in favor of the motion?
Aye.
Aye. Any opposed? Okay. You have your relief by unanimous consent.
Thank you very much, everyone. Have a nice night.
Thank you.
Would you like your microphone back? Should I leave this out here? Just leave it here?
Next item of business. Go to the beginning of the agenda. Appeal number 2915, 134 North Wayne Avenue. The applicant, 134 Partners LP, property located at 134 North Wayne Avenue and zone WBOD, which is Wayne business, what's the O for? Overlay district, all right. Seeks relief from section 280-53-15B, C, F, and M, 280-53-15B, and 280-119D in regard to signage. Okay, let's get the right thing out.
That's very good. You solemnly swear or affirm this testimony about the whole truth and nothing but the truth.
I swear.
State your full name, please, for the record.
Bradley Palmer.
Proceed when ready, sir.
Thank you. My name is Brad Palmer. I represent 134 Partners, the owner of the property at 134 North Wayne Avenue, also commonly known as the Suburban Building. And the context of our appearance here this evening is addressing the alphabet soup there of the code that Mr. Cutler just read that applies in our situation to a hardship upon tenants, retail businesses specifically, to be able to communicate their businesses to the environment around them because of the unique physical condition and architectural characteristics of the property that are peculiar to this building and are part of the wonderful ability to use the building the way it's being used and the attractiveness to it as part of the streetscape in the Wayne Central Business District. However, the marriage of old and new requires some creative solutions. It also requires some trade-offs, and that's the context of where I'm standing here this evening with this appeal for relief regarding the ability for the business in the building to be able to sign themselves on the building. So the issue of being able to sign the businesses in accordance with the very specific parameters in the signage code is what its issue for seeking relief. So in your packet, there are a couple of photos. And if you go to a page entitled Photo Slide 2, it's the second photo. The first photo is this shot showing giving us a general view of the property. This property sits on North Wayne Avenue, not quite to the bridge of the train station, sitting between the Great American Pub and on the right with Paula's Pizza on the left. The building sits between two little alleys. The one viewable in this photo is on the south, runs along the south facade of the property. It goes back to a main lobby entrance on the side of the building, which is signed with a prominent blade sign over the lobby at the back of the alley. We're looking at the east facade here. So on issue number 1, a projecting sign mounted on the east facade of the building. This photo slide 2. Shows the east facade. Now this building was built around 1900. It was one of the first commercial properties in Wayne. If you're in City or City, Philadelphia, you'll recognize some of the treatments that were used in the design of this building, where it's meant to sit out on the sidewalk. It has retail tenants on the front, each sitting on either side with large plate windows, one dedicated to each. It has tenants in the lower level that are walk down, and the walk-up nature provides them with a half-level view of windows across the front on the sidewalk. It's common downtown. It's not common in the suburbs. So filling this building, and in particular this front part of the facade of the retail portion that we're looking at, has 4 tenants in it. one behind either of the first level large windows, and then one behind the smaller lower level windows. And with the nature of railings, cascading steps, a walk back in entryway, lots of glass, divided lights above the glass, paneling on the sides, there's really a limited opportunity for modern conventional signage. You wouldn't design a retail building facade to look this way these days because there's a standard approach that's understood that's needed for signage. So we've done a lot of work in being creative and sensitive both to the facade and also to the businesses in terms of being able to let the community know that they're in there. One of the hurdles that we're up against is there's a small projecting sign visible in this photo toward the left, and that sign is for tenants on the left side of the building. There is no projecting sign on the right, and code allows one projecting sign per facade of a building. So the appeal is for a mirror projecting sign for the other side. The projecting sign would be the same as this sign in design and size. It would be a mirror location on the other side of the building. Last month, the Design Review Board approved this sign pending zoning relief.
So it's simply one single sign that's causing all this hubbub?
I think
The
there's
hinged
more to
signs
come.
also, right?
John.
Pardon me?
There's more to come, I think.
Oh, okay.
But what is on the existing projecting sign? Who's advertised on that?
That is Little Nest Photos, who has a business. It's called Little Nest Portraits.
So it's the tenant that's on that side of that
Correct.
floor. And this new sign is just for the tenant that's on the other side of that floor, right?
It's for the tenants on the other side, because these are stacked tenants, and that sign is yet to get another sign underneath for the tenant below. And the same with the other side. The other side will have two signs hanging from a projecting sign on that side.
Would that be in lieu of the hinged signs that sit on the ground?
That is we saw that as a different issue.
Uh-huh.
This is a permanent sign. Those are permanent slots. So given the longevity of this building so far, it's going to be around a lot longer, and it's likely to have tenant turnover. These signs would be allotted to those spaces for those tenants.
But you're asking for hinged signs also, right?
They're actually asking for a number of signs, yeah.
Correct.
Yeah.
Correct. That's a portable sign
Right.
in a different place.
I understand.
Okay.
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 But you were talking about hanging an additional sign below the existing sign there.
Yes.
And I didn't see that. Maybe I just missed it, but I didn't see that part of this.
I'm sorry. That's true. That's correct.
All right.
I have two questions.
The-
One, you mentioned 4 tenants, so it's 1 below level, 2 first level, and then second level?
And I could point it with my finger, I think. There's a lower level tenant
Right.
here, which
Yes.
is the Wayne Donut and Ice Cream Bar.
Okay.
And then on the opposite side, at the same lower level,
Okay, so there's two lower level, 2
Polish
first
Salon.
level.
Yeah,
Okay.
and then above it is a tenant, and above it is another tenant.
Do we have a plan that shows each sign you're requesting as to dimensions of the sign, how far up from the ground it is, and so forth? We have the photos.
I believe that was in the Design Review Board packet. I'm sorry that didn't make it into this packet.
Because candidly, I'm concerned that we should be giving approvals for specific sign sizes and elevations, and not sort of conceptually put these signs out wherever you want.
Well, I see we granted approval on Appeal 2862 to a projecting sign. I presume that that's the one we're seeing in this photo. Now, was there a size limitation put on that? Because the code itself, I think, puts a limit, but the fact is you're asking for a second of the same type of sign. So the question is, what will the total area be?
That sign was not that appeal. That appeal,
It's a sign in the alley.
it
Oh, was
must be
that
the alley
Oh,
sign.
the big alley sign? So where was that approved then, that projecting sign?
That's, in this photo right here, down the alley on the south facade, there's a projecting sign.
So I'm saying, well, then how was that one approved, that projecting sign that's on the
That's a
photo?
different facade. Code allows one projecting sign per facade.
Per facade. Okay, so your issue is that it's a second one.
Yeah,
Not that-
so our issue is being able to provide a projecting sign, and we understand the point of projecting sign to be a complement to a face-on sign. If you're looking straight at a business or at a window, you can see their signage in the window. If you're approaching it from the sidewalk, the projecting sign gives added signage to the business so that you can see it from both angles. And
I'm just going to be real direct and apologize. Tell me what signs you want to put in. At this point, I know, I see the one projecting sign that exists. What do you want relief to do? Because I can't figure it out yet.
all right, I'm sorry I wasn't clear on
Get
it.
right to it. What do you want to do?
There's an existing projecting sign on this facade.
Right?
For that side, I want to duplicate that and put it on the other side so that the other tenants on the other side also have a projecting sign.
Okay, and then I'm a bit confused because a little bit earlier, somebody said, well, that's the first. But now you're saying you're looking for relief to
And-
add one additional sign, which is a corresponding hanging sign comparable to the one that exists, except on the other side.
Correct. For this part of the code, there's several parts of the code for different signs. There are 3 signs that we're coming for.
Tell me about all the signs.
Okay, thanks. One is a projecting sign on this facade.
Okay.
That's for retail businesses. One is a projecting sign on the north facade for building identification. And one sign is for the patio for the lower level tenants. Actually, one sign for each of them.
Last one is the hinge sign, is that right?
Correct.
Okay.
And the middle one is on slide 4, photo slide 4. Is that the drawing in the upper right-hand corner?
Yep. The middle one is the north facade projecting sign. That projecting sign is allowed by code. It's not allowed to be at the height that it needs to be. The nature of the north facade of the building is such that it is hidden, the lower level of it, half of it is hidden by the Great American Pub. And the only place for a building identification sign on the north facade is higher up on the building. Code does not allow a sign to go to the height that the sign needs to go to.
Okay, does
in
everybody
order to be
see that
visible.
sign on photo slide 4? Just as the
We don't know
suburban.
how high it is, do we?
We need signs schematics. I mean, I think
Yeah, we
that
do.
what we need is plans that show the existing signs and how they got there, how they were authorized or whether they were right, and then to be clearly able to see the first sign, here's what we want in terms of size, how far up off the ground it is, and, all the dimensions, for projecting and so forth, and then sign 2 and the same stuff. It's got to be clear, because we're going back, I'm lost.
Appeal
It is,
2862,
Mr. Ryan-
I remember that. I mean, if you did the same thing you did for that, because I think you're asking for somewhat similar relief, and you had a lot of great detail, construction of the sign, materials, the illumination, which was very helpful for us. I think that's what we need in order to kind of move on this, because
Okay,
I
we-
knew I could figure out 2 of the signs. I'm not figuring out the 3rd sign.
Okay.
It's got to be
That-
on the 4
That's-
corners of the
that's-
plans.
Honestly, that's part of the trick of sign-related issues, is it design review board or is it zoning? And design review board had all these details. We should have submitted all of this detail perhaps for zoning as well.
You have to understand, if we grant you relief to put something up at a height other than as allowed, we have to be very specific. We're not going to give you a blanket approval to put it wherever you please.
Right.
And last time, I believe we gave you approval because we had to get it high enough so that vehicles going down that alley wouldn't hit it. Now, is this alley owned by you, the north alley?
It is.
And do vehicles use that alley as well?
They don't.
They don't. So what's the reason for?
The reason is it's obscured by the building next door. There's no way to see that's a picture from the northwest corner. The placement of the sign up here is what's necessary in order for it to be seen. The nature of the Great American Pub being under it,
Is that view in our materials?
Yeah.
Where is it?
slide 5, the bottom left.
thank you.
Oh, it's similar.
That doesn't look the same.
No.
No.
It's a different perspective, but it's the same corner. Yeah, that's not in our packet.
This photo's a little small, so I brought this additional one along. The point is, the sign needs to be up at the second story of this building, and in order to be on the second story of the building, it's going to sit higher than the maximum height allowed for a projecting sign by code, which is 12 feet. The second story starts above 12 feet. The sign is as designed and presented to the design review board stops at the top of the structure. It doesn't extend beyond the top. I'd suggest that to limit it to the height of the building.
I think
Would
we're
be
going to need
fine.
to see more detail on this.
Yeah, I think.
Yeah. Is there an entrance to the building on that alley, like there is on the other alley?
On the north,
Yes.
there is a door at the end of that alley that goes inside the building.
And you have
It's
no
not a
projecting
prominent
sign on
entrance,
that?
though. It's not a prominent entrance. This is so that the building can be identified from the west and from the north and from the northeast.
And honestly, you may have an issue in H, in that same provision, that no projecting sign may be closer than 12 feet to any other projecting sign, which we don't have measurements to show the projecting sign that you want to get on the right-hand side and what the distance of that is to the projecting sign in that picture.
It would be positioned back behind that first window. So
Be
I'm
nice to see
confident it
that.
would.
See, the problem is we
Yeah.
have to put all this in the order and in the motion, and we don't have any detail or a plan to refer to with detail. So it's
Okay.
a bit of an issue. But putting that aside for a second, I see in one of your photos, you have a hinge sign in front of the tenant on the left side as you face the building.
That's right.
Now, was that an approved sign?
That, the design review board doesn't approve hinge signs.
I'm not talking about them, I'm talking about the zoning board.
No, it's not. That sign is no
Well,
longer
I think
there.
it's got to be attached to the, they're not allowed to swing, they have to be fixed by hardware to the building or to the ground. I don't know that you're allowed to have a sandwich sign like that.
That's true. And the tenant was advised of that and took this sign down. But this photo was taken when the sign was there.
Nobody wants approval for the sign that was already there. You just want to do the same thing in the future. Some people prefer to ask forgiveness and permission, but when it comes to zoning, you have to ask for the permission first. So,
Absolutely. And the tenant wasn't aware of,
you've just
It
put
was in the
something in the
code, so-
record that shows you're in violation of the zoning code.
That's
You
true.
understand that?
The good news, it's
that's
portable.
true. But only for one day, I think. They were advised that it was in violation, and that's why the tenant removed the sign. So for this sign, as you correctly pointed out, it is a portable sign, and as I'm sure you know, portable signs are not generally allowed in Wayne. And the context for the appeal for a sign similar to this, a hinge sign that could be placed on this patio, it's not a sidewalk, it's a patio there. It's not evident by these photos necessarily. Is related to solving this puzzle of how can these lower level retail tenants receive adequate signage. And this sign is a solution for this situation on this unique property at this site. It's a simple, economical, effective option for signage. These lower-level tenants are faced with this hardship of not being able to place adequate signage on this building, and they're not found. Gabby Walker represents the Wayne Donut and Ice Cream Bar, and I asked her to come and speak to the matter from firsthand experience.
Excuse me, what ice cream bar? The name? I couldn't hear you.
It's called the Wayne Donut and Ice Cream Bar.
You're a tenant of the building?
Yes.
And you're on, could you use the other mics? You could both have a mic?
Should I swear her in?
Yes, please.
Ma'am, if you'll raise your right hand, you promise to tell the truth, the whole truth, nothing but the truth.
I do.
State your name for the record, please, and spell it.
Gabriella Walker, Gabriela Walker.
You're a tenant, and when you face the building from the street, are you with the lower left? Is that what you are?
Correct.
Then she's not the tenant who's going to have this hinge sign?
She is the tenant that's going to have this hinge sign. And the other tenant isn't represented here this evening, but
So are you asking for approval of 2 hinge signs?
that's correct.
Oh.
We have 2 lower-level tenants, one on either side.
Mr. Chairman, if there's this much confusion about what's being requested, I think we should ask the applicant to come back at a future meeting with more detailed plans specifying the proposed location and dimensions of the signs for which relief is requested. I think that's the direction we should go. I would suggest, out of deference to the witness who came, we could let her provide her testimony regarding the business requirements of her tenancy, and then let's continue this to a future meeting.
Then you would you agree to continue this and come back and submit something before the next hearing that we can review?
Absolutely.
We really should get it to us in advance, because it's hard to be reviewing details when we're sitting up here the
Yeah,
first time.
I fully appreciate the difficulty of wrestling with these details.
Okay.
We'll submit
But
the-
All right.
that being said, could you please share with the board your perspective of your needs as a tenant for signage at this location?
Sure. Because we are a lower level business, we are finding some challenges to be found by the community. And sure. Because we are a lower level tenant, there are some challenges for the community to find us because we are in a location that is a little different from most businesses. Instead of walking straight into a business, they would have to engage with us into lower steps. And we're trying to find a way of, A, letting the community know that we're there, and B, also those that are aware of our presence find us in a easier manner. We want to embrace the community, but if they're having difficulty finding us, it's hard to embrace the community in that manner. So we're looking for a signage, whether it's portable or on the facade of the building, so that we can make ourselves available to serve the community around us.
Thank you.
Gabby, tell them what you had come to me with in terms of your interaction with community and customers.
Sure. I've actually been approached by several members of the community from various ages and surrounding businesses, and questioned why we didn't have a more prominent sign besides our windows. And we just said that we were experiencing some newness and difficulties in understanding what the policies and the area requires and allows. So a lot of the new customers expressed difficulty in finding us, and so we're just trying to help facilitate some of that interactions with our customers and better customer rapport.
Is there anything else you want us to hear on this tonight?
I don't believe so. Thank you. We'll come back.
Is
with the
anybody else here
dimensions.
to be heard on this? Anybody have anything to say? Okay, because I thought other people turned out. We'd want to give them a chance to. Because you understand, if we had to vote on this right now, the likelihood is it's not going to be favorable, and I don't see how we could even frame a proper motion or a decree. So we are going to continue this to next time. Any formalities we need to go through, John?
They've already given us the extension of time on the record for the hearing of this, and then a corresponding extension from the conclusion of hearings to get our 45-day period for getting the written decision out. You agree with those? The extensions? That we extend the period for hearing this till the next hearing, and that our period of time, 45 days to get our decision out, starts running when we conclude hearings. Is that acceptable?
Yes.
Okay.
Just to add, we're looking for specific heights, dimensions of the signs, where they're going to be located. Okay.
If they're going to be
Excellent.
illuminated, information on that, because you know that's an uphill battle, getting approval on the illumination. So whatever you want to put in front of us, you have to put in front of us in detail, or we won't be able to act, at least not the way you want us to act, that's for sure.
Great. No, I apologize that I didn't bring all of that with me this evening and present the way it needed to be presented. Thank you for the extension.
July, I think it's 17th, it's printed funny here on the thing, July 17th, third Thursday of the month. And we really would appreciate if you get materials to the township at least 10 days before that, so they can get it to us. We can spread it out on whatever surface at home or in the office. Thank you. Okay, next on the agenda is Appeal 2916, 240 to 252 Radnor Chester Road. The applicant, Radnor Chester Road Investment LP and 252 RCR Investments LP, property located at 240, 252 Radnor Chester Road, and split-zoned PB and R1, seeks variances from the following sections of the zoning code. Number 1, 280-60B, relating to building area. Number 2, 280-60C, relating to setback along a 50-foot by 50-foot parcel owned by the township. And 3, 280-61D, relating to buffer along the 50 by 50-foot township-owned parcel. Applicant seeks a special exception under 280-101A1, a variance from the cited sections, or contends that it is permitted by right or as a decrease in existing nonconformity from the following sections of the zoning code. Number 1, 280-60C, regarding continuation of the existing rear yard setback on the rear property line in common with Radnor Financial Center for the parking structure. And number 2, 280-4, regarding continuation of the existing size of parking spaces in parking structure. In addition, applicant seeks any other zoning or alternative relief required pursuant to plans presented with application. Now, before we get started, it looks to me like we are superseding A6 with
Yes.
A28 and superseding A7 with A29. Is that correct?
Exactly right.
Okay.
Now, may I, you have mics up there. Should I take those mics?
Nick, I have another question to ask you because something was a little confusing to me.
Right.
In the memorandum of law, on page 2,
Right?
you have a section about a third of the way down the page says, furthermore, applicant is willing to condition any approval on the
Right.
following. And one of the items that you mention is modify the site to accommodate the relocation of
Right.
the Radnor Chester Road and Raider Road traffic signalization, et cetera.
Right.
Now, further back in your, on page 7, just below the midpoint of the page, there's a sentence that says, "The applicant has agreed to condition any zoning approval on the new signalization and the applicant's relocation of its ingress and egress at its own expense." So that condition was not mentioned earlier, so I'm not sure what your intention is.
No.
It is conditioned upon the approval of the signalization?
Right, right. I thought that is covered by 2, that we're willing to condition any approval in the following, number 2.
That says you'll modify the site to accommodate. Doesn't say your
oh.
approval will be conditioned upon it.
Okay.
So that is your intention? that
Yes,
yeah,
yes.
Okay. Thanks for clarifying.
Okay. And I just want to make, we have, so everyone has A1 to A29. Okay. No. What do you want? I have copies of the plans. I can get it to you. Okay.
Has land development started on this yet?
No.
What is the time frame for getting PennDOT, anticipated time frame for the signalization?
You know, I hate, I'm going to look in the back of the room, and Amy, I don't know if, better identify yourself.
You need to
Hi, I'm Amy Kaminsky. I'm the traffic engineer for Radnor Township. Probably should swear in.
Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
And state your name, please.
Amy Kaminsky, Kaminski, Gilmore and Associates. We made our first submission to PennDOT a few weeks ago, and we've been in contact with them and working with them for the past year, and we anticipate constructing the signal this summer. However, we understand that the driveway for 240 RCR would not be completed by that time. So there's going to need to be some additional work done to the intersection to allow him to take access through the intersection once he goes through the land development process and constructs his driveway. And along
Excuse me,
with-
I think you ought to clarify for the record for whom you speak, who you represent.
I represent the township. I was
So
asked to
everybody
come
knows.
in.
This is not the developers.
I am not the
traffic expert.
developer's traffic engineer. I work on behalf of the township, and I was asked to come in because there may be some questions about access, Radar Road, and the signalization of the intersection. So if you have any questions about that, we are planning on constructing it without the access to the site that you're discussing right now. And as he works through the land development process, if the access is denied, then he would continue to use the access that's existing. If he's approved and moves through the land development process, then he would come in and take access directly across from Radar Road, and he would, in my opinion, would be responsible for putting in the mast arm that would service his driveway and any other improvements that would be required to allow him to come through the intersection.
And what is the status? You're saying that it is fully approved, is it?
It is not fully approved. We've made the submission to PennDOT. We have all the bid documents that went out to bid, was my understanding, about a week or two ago. And we have the intention of constructing that over the summer, in time for school to start in September.
But you're still waiting, you still can't proceed with this until you haven't got the approval from PennDOT to it.
We haven't gotten the design approval from PennDOT yet, correct? That is true. PennDOT's been made aware of it for a year. We've been working together cooperatively with the school district and Mr. Gross to attain those approvals.
Have you been given the opportunity to make a thorough review of the traffic report?
I
that's
have
been
not
submitted to
reviewed
us?
it. I typically don't get those until the zoning approval comes in, unless there's a specific request for me to look at it prior to a zoning discussion.
Okay.
We did submit some of the information that was provided in that to PennDOT, because PennDOT was interested in knowing what the improvements might be on that site as far as from a traffic perspective, to make sure that that signal could accommodate the traffic coming out of his site if it was developed across from Radar Road.
Okay, that's,
Amy, perhaps, could you describe what the signalization would look like and the ingress and egress? Can you do that, or, I mean, I can have one of our people do it, but you-
That's fine.
let me, I'm going to put
What
up,
magic are you going to pull up?
nothing. I'm just going to pull up the plan.
Well, Nick, if you have the ability to introduce that with your own people,
Sure,
I
I
think
mean,
it
we
would
can,
make more
yeah.
sense than to have the township's professional testifying as your witness when she hasn't been prepared.
That's okay. No, I was fine. We've talked, this was discussed previously, so.
They've been involved in the process.
No, I understand it's not a
Okay.
hostile situation. I'm just
Okay.
saying, since you're able to present it.
If I could at least clarify that the access as it's presented on here is not something that would probably be accepted by PennDOT, but it has not been fully engineered. Right now, this is in what I would call a sketch plan phase, and we haven't commented on it, we haven't reviewed it or given any kind of direction on what we would anticipate would be the final design. I just don't believe that the ramp that's coming out from this area would be done in that fashion, if that helps you at all. But I have no doubt that he would be
I
able to
mean,
make
that's
access.
the right turn lane?
Yes,
Yeah.
that's not how we would want to see that design, and I know that PennDOT has an opinion about that, too.
Thank you.
Sure.
I mean, if we're going to know what PennDOT, presume we expect to know what PennDOT will approve or not approve fairly quickly, right?
Yes, and we're willing to condition any approval on the PennDOT approval and the PennDOT design.
An installation?
And yes, and we would be responsible for our own installation.
No, but condition on the approval and installation of this signalization.
Yes, absolutely.
So no work would be commenced under our approval until that's in hand?
Correct, because I don't think we'd be,
Yeah.
I mean, what
I
if
don't think that's an
PennDOT comes
issue.
back
Yeah.
with something different that would change, presumably the traffic study? We have said the same traffic study as we had the last time.
Yes, it is, it
we
is.
Concerned.
It is.
And one of the concerns that I personally had during the hearings and is reflected in the decision is that we don't know what will be approved and what kind of private sign-offs are needed, and the traffic improvements become speculative. And there's case law, which the opinion cites, that a burden on traffic cannot be met by traffic measures and improvements, which may never happen and over which the applicant has control. I'm wondering, does it make sense to proceed now as opposed to if you're expecting to have the traffic lined up and the approvals in place and whatever consents you need, and be able to come with us and say, this is what we intend to do on the traffic. We have the consents for it. Here is a study that shows that based on what we have in our hand and can do and can commit to, this would be how the traffic is affected. Because I'm a little at sea on this, Nick, right now.
Yeah, see,
It's a moving target.
Yeah, we're willing to condition any approval on the PennDOT and the township and the school district agreeing to what this intersection will look like. So we think that would cover it. It's not a situation where you're requiring it as a condition. We're agreeing as a condition, that's acceptable. And part of the problem we have, of course, is we have 252 under agreement of sale that is going to expire. So we need some sort of approval in order to go forward.
About 9 more months or something? Did it get extended to April of next year or something?
Shell, do you know off the top of your head when it was extended to?
I think it's in your,
Yeah, you're going to have to come up.
Just state your name again, you were previously sworn.
Could I say something?
No, he actually was not, it's not in this hearing.
Oh,
well, we don't know why you're here, George. Why don't you tell us?
I'm here to enter my appearance on behalf of some neighboring property
To help
owners.
yourself to the mic and talk to our television audience.
George Brosman, I would like to ask that my appearance be entered and my clients, who I will identify in a moment, be made party to this proceeding. They're entities that are related to Brandywine Realty Trust, and they own properties that are immediately adjacent to this property and in the area. I'll identify the names of the entities and the addresses of the properties that I have. The entities are Radnor Properties -201 KOP LP, Radnor Properties SDC LP. Another entity is 555 LA LP. Another is Radnor Center Associates, and another is Radnor Properties-200 RCLP. They own the properties at 555 East Lancaster Avenue, which is the large building where the Susanna Fu is, for example. They own 130, 150, 170, and 200 Radnor Chester Road. 200 Radnor Chester Road is the new building that has been built. It's right next to this property. That's the subject of the application. They own 201 King of Prussia Road, and they own 1 Radnor Corporate Center, 2, 3, 4, and 5 Radnor Corporate Center. And we would ask that we be made parties to this proceeding.
Mr. Solicitor, do they have standing?
Yes, I would believe they do. There's been no objection made to standing.
I'm not objecting to standing. I don't know if the King of Prussia Road or the Radnor or the Madison Ford Road properties have standing, but certainly Brandywine has standing in this. They're an adjacent neighbor. I'm not going to raise any objection.
Well, you're in, Brother Brosman, for better or for worse.
Okay, I should swear him in. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes, I do.
And state your name for the record, please.
Sheldon Gross.
Okay, the question, I believe, well, why don't we start from the beginning, all right? So, Shelley, you're the owner, current owner, or your entity's a current owner of 240 Radnor Chester Road, correct?
Yes.
And you have under agreement of sale 252 Radnor Chester Road.
Yes.
I know there's been an addendum to that agreement. Do you recall how long that is for?
Closing before December 31st, 2014.
Okay, so that's closing before December 31st, all right. Now,
It's curious, because wasn't it extended so you don't have to give notice till 2015?
No. 2014.
Nick, I have a question
yeah,
about
I'm looking at C.
the amendment you gave us.
Yeah, it says if buyer does not provide termination notice prior to January 2nd, 2015, then settlement shall be held on or before January 16th, 2015. Yes.
I apologize, it's
Yeah,
January
he said
6th.
December 31st.
Yes.
I believe it's January 16th. It's on page 2, sub C, I think, of the addendum. Remember, he still has to go through the land development process as well. Shelley, we were in with a previous plan a couple months ago before the board that was denied. What's the main difference between that plan and this plan that you're seeing here this evening?
All of the proposed modifications to the property take place in the PB area, PB zoned area, with nothing being modified in the R1, or no additions or modifications to the R1 section of the property.
And if we can just quickly go through the property again, I'm showing, and the board has what's been marked as A4, and A4 just shows a zoning map for Radnor Township, and it shows 240 as being in the PB area, correct?
Yes.
And 252 in the residential area.
Yes.
All right, and it shows the PB, and behind 240 is that Radnor Financial Center?
Yes.
And that's in the PB zone, and that's also 555 Lancaster Avenue is included in the PB zone.
Yes.
All right, and then next to 240, and that's the one that George referred to, the pads, the 4 or 5 restaurant pads there.
Yes, that's correct.
Okay. And then also, there's an R1 strip around the PB zone, is that right?
Yes.
And that, in effect, has created a split zoning district, not only for 240, but 252 being in the residential area.
That is correct.
And then adjacent to you also is the PLO district. And what's in that PLO district there?
There's a 3-story office building owned by, I think it's Schiffer and Barroway.
Okay, and then in the R1, that's the Radnor Way properties, the Radnor Way cul-de-sac. Is that correct?
Yes.
Okay. If we can refer to A5, and the board will note, one of the relief we're asking for is for the size of the parking spaces in the parking structure, not the surface parking spaces, but just in the parking structure. And A5 just indicates that it was granted to place that parking structure in the current location that it's in, as well as the size of those spaces being 8.5 by 19. So that's why 8.5 is in your zoning packet.
Excuse me, Nick, quick clarification. You had answered the question about what was different from the prior plans, sort of technically in connection with zoning districts. Sort of as plain vanilla construction, what's different? You cut back the garage?
The garage, the ramp is the currently approved ramp that was approved in 2009 when Keystone came in, Property Group came in for their application. The garage remains in the same footprint that exists today, except that it's going to be elevated so that the structure will actually contain the, I think it's 650 spaces in total, and that will be spread out over the garage. But the key was that the ramping, which was in our previous submission, was contained in the R1 area. By redesign, the ramping has been moved internal, and it's been moved in towards the PB area.
And on the plan you're pointing to, where is the entrance to the proposed garage?
The entrance for the lower level, there's two entrances. There's an entrance here, and there's an entrance here.
And that's an existing entrance?
These are existing. This is all existing. And then the ramp
When you
is-
say we're going to have to
I apologize.
keep taking a record, so we're going to have to be more specific when you say this is existing.
I apologize.
You're referring to the ramp in the R1 area as
Yes.
existing.
There's an existing ramp in the R1 area that carries the traffic, the vehicles, to the second deck. Then from the second deck to the third deck, there'll be an internal ramping system, and then from the third deck up, there'll be another internal ramping system. The ramp will not be modified. It's the existing ramp that's in the R1 currently, but there'll be no other additional construction in the R1 area. So the only thing, it's all existing conditions in the R1. The parking is existing, and basically what we're doing in this particular scenario is building the building, creating or constructing the building in the existing parking lot in the PB area. That's a three-story
Excuse me,
building.
I think I may have had a mental lapse here. You are or are not changing anything in the R1 portion? Are you just changing the ramp around a little bit? You're
No.
not building the garage, I
No.
gather that much.
No, I'm sorry, Mr. Ryan. The ramp remains the existing ramp today.
Okay,
There'll be no changes in the R1. It's all existing conditions.
okay.
And the only other change in the R1, you may recall, there's an existing nonconformity as to 252 with the office building regarding setbacks and use, and that building will be removed.
It's being demolished. What is before you today, where the areas that are showing as green on this drawing in color, will all be green areas. So in essence, what we've done is we've taken parking lot, which is existing, impervious and asphalt, and we've now converted that into green areas. So if you look at the perimeter around the building, this is all green. The area in the front of the building across from 252 and 240 will all be green and landscaped.
Excuse me, I just recall last time we looked at this, right at the edge of that ramp, there was a proposed kind of a big wall, and we had a lot of discussion about that wall. So that wall's not going to be there anymore.
The wall, there is no wall in the front of this ramp. The ramp remains, the ramp is existing in this particular location.
So where does the third floor start, sort of?
They start on the PB side. It actually runs on the PB side, and it continues along the existing, the orange dotted line, but does not go past the PB line.
Okay, so when you come up on the existing ramp as it is now, after the improvements, you're going to be like coming underneath the third layer.
Yes, that's correct. And then the fourth layer will be on top of that.
Got it.
So basically, the ramp will go in place. We'll be removing all the light standards that are on the parking lot that exist today. They'll be replaced with low-profile directed lighting, both on the roof deck and along the surface parking spaces. So, I'm sorry.
Thank you.
The height of that garage structure will be what?
It'll be the average height is under 38 feet.
And how about on that?
On the east side, it's 30 feet. So most
Thank
of the other side of the structure brings down the average to under 38 feet.
Mr. Gross, do you have any elevations of that or any sort of rendering of what that is going to look like?
At this point, it's only preliminary design, but we are willing to stipulate it will be under the 38 feet, the average calculation. So it will not exceed the 38 feet.
Referring back to Mr. Nagel's observation about the wall, there was,
I'm sorry?
again, we don't necessarily get into aesthetics, but to the extent that there's a concern that a view from residential areas is such that they get a wall,
Valid point.
we're now
We are
2 floors up.
actually, what we've agreed to do is the wall will be designed in a residential, quote, "friendly" way. I'm sorry. And we've entered into an arrangement with the community. We're anticipating putting planter boxes or some type of treatment along the wall. And the wall is actually, because the wall does not go down to ground level any longer, we're not going to be capable of carrying the ivy down the screening, which we had anticipated doing. And the ivy screening is going to be replaced by the planter boxes, but keeping in mind that it's only on the above-grade calculation facing the eastern side, the residential side, is somewhere between 30 and 32 feet above grade.
I just handed up to the board, Shelley's been referring to this colored site plan, and so I handed up to the board actually a copy of that color site plan and marked it as A31. So you know when he says green, what we're referring to.
I apologize.
What if we're colorblind?
And again, I know the board's familiar with it, but let me just make certain it gets in the record. A8 is the existing building. Down in this corner, which I've marked as A9. A8 is the existing 240 site. A9 is the existing 252 site. And Shelley, your testimony is that this office building in this location will be removed, is that correct?
It's currently a building that was originally designed for residential, and then eventually was used became an office for an accounting firm and a benefits firm. And the building will be raised as part of this process and will be replaced with green area.
There was a parcel owned by the township. It's hard to see on the
That's on,
green. It's on the A28.
yeah, and you can see it on A8 also, the existing condition.
Yeah.
A8, just that 50 by 50-foot parcel.
When this, in the prior case, we haven't heard this case before, the prior case, that was not under agreement. There was talk about acquiring that from the township. What is the status of that parcel right now?
We have actually had discussions with the township. There's 3 options out there. Number one, just so you know, the current use of that piece of ground it's part of the buffer.
Mm-hmm.
So there's buffering in there that is applicable to the property line.
Mm-hmm.
So it's not an uncommon use or an existing nonconformity as far as putting an additional buffer in there. The options that are before us are if the township can arrange for us to acquire that 50 by 50 piece, we're going to acquire it. Second option would be that we would lease it, or 3, we would get a consent to put the buffer on there. And I believe there was testimony or dialogue with Peter on Tuesday night about exactly that condition, those 3 items. Those are the 3 options before us.
Okay, Tuesday night was...
I'm sorry.
Planning Commission is referring to Peter Nelson, he's a solicitor for the Planning Commission.
I apologize. It was, the application was vetted by the Planning Commission on Tuesday night, and that was part of the dialogue that was during that
Okay.
camp.
Before you proceed, you just handed us with Exhibit 31.
Correct. That's the same.
We don't have a 30.
I would, yeah, I know.
Oh,
There's a
okay.
30 coming in.
Okay.
I had already marked it, that's why I didn't get on the list.
Just want to make sure I didn't have a lapse.
I guess a couple of things also. You claim the ability to expand the non-conforming parking spaces and also build on the northern border of the lot on non-conformance, right?
Correct.
My understanding is that garage was created by order of the zoning board, so I don't think that's expandable by.
And we did request a variance for that as well.
Okay, but I mean, I just want to make sure that.
The last hearing, I understand your position.
Okay, yeah, my advice is that would have to be done by variance, not by nonconformance, because you can't expand zoning board approval by principles of nonconformance.
Although, if I recall correctly, they said it was non-conforming back when they granted it, however many years ago.
Well, I'm not sure, to be honest, what was said, but it's the order that governs. I'm not trying to be smart or
Sure,
anything.
understand.
I can only go by the order, and I wish I could remember
We
better.
pay you to be smart, John. Please be smart.
Yeah, and actually, that order just says it's granting relief.
Yes.
It didn't say special exception, didn't say, non-conformity, didn't say
Yeah. Well, yeah,
variance.
but
It
if
says
special
granting.
exception is not
No.
expandable
Yeah,
either.
well, we now know special exception isn't relevant in those type of.
Yes.
It's either by right or variance.
Nonconformance.
Just referring to A8 again, Shelley, for the record. This shows the residential PV split here in the zoning district on the property.
Yes.
correct? And then it also shows that you already discussed the existing parking structure, right?
Yes.
And the ramp up to the existing parking structure. And then, as we mentioned before, on A9, there's an existing nonconformity regarding use in front yard setback.
Nick, keep your voice up.
Okay. There's an existing nonconformity at 252 regarding use in front yard setback. Is that accurate?
Yes, that's correct.
Now, just going to show you a couple photographs for the record. Again, I think everyone's familiar with the site, but A13, if you can just tell the board what A13 represents.
A13 is the existing front of the building at 240 Radnor Chester Road.
And A14?
A14 is 252 Radnor Chester Road, showing the 18 feet from the curb line and a car passing by it.
And A15?
Again, the non-conforming building on 252.
Okay, A16?
This happens to be a typical day in the life of our current parking deck. As you may recall from our previous discussions, our tenant, Mainline Health, has the requirement to have about 80 to 100 flex spaces on the premises because three days a month they bring in associates from around the surrounding hospitals and from new tenant or new hires, and they do an orientation for the new hires. It's usually every other Monday. So the requirement is for 390 to 400 spaces of active use, and then we have 80 to 100 spaces that are used for flex space for the continuing use for these variable type arrangements.
And actually, we have A30 is a letter from Mainline Health.
So this photo was taken during a business day, during business hours?
Yes, sir.
That's why you submitted it?
Yes, sir. And I could have taken a photo on one of the second Mondays of the month, which you would have seen the lot was pretty active and full.
This is the upper level of the deck, and this is going to have two levels on top of it now?
Yes.
Shell, on A17, can you explain to the board, you have something outlined here. This is what you're showing there on A17.
Sorry for the artist. It's not to scale, and the artist's efforts here. Basically, this is the 50-foot by 50-foot section that is lined out, showing the piece of that's from the township. As you can see the buffer that exists currently in that area of 50 by 50, the township designated space. And the fence is our parking lot, so we're actually parking right up to the 50 by 50 piece.
By the way, does anybody know how the township has access to that piece? Is there a right-of-way for
They
it?
have no right-of-way, they have no easement, they just, if they needed it,
They'd have to claim an easement by necessity.
nobody's going to stop them, but, yeah.
Well, I was just wondering how that affects the improvements in the buffering and all the other things.
There's no requirement at all.
Landscaping and all.
Yeah.
Guess township could always condemn it what it needed to.
The statute for easement by necessity, they may proceed under that. Yeah.
It's still, I think the easement by necessity, though, it's still, you have a viewer and a compensation.
I've marked as A30, this is the letter from Mainline Health that we were talking about. And in particular, when I give it to you, paragraph 3 of this letter And 4 talks about the need for the parking spaces and why they need the spaces. That's what I've marked as A30.
Okay, so I should mark that.
Here's some additional.
You're not requesting any relief on number of parking spaces?
No.
Because I think there was some discussion in the prior appeal about some spaces being already, we had and talked about it again today. If there's no request for a variance from the number, it's beyond the jurisdiction of this board to consider it. But if the use of the spaces were somehow to be, classified as not being fully available and you were underparked, that issue was not before the board, right?
No. And actually, and we mentioned this last time, actually for the new building, we are providing less spaces than required by code, but the total site complies with the required number of parking spaces and does have excess parking spaces over what is required by code.
Okay, I just note that even if the board were to approve this, that issue is not before the board and has not been placed before the board.
Yes, yeah, we're not asking for any relief on
Issues that
that.
aren't placed before the board are not, there's no relief given for such issues.
Right. And as I mentioned, the letter basically, at paragraph 3 and 4 talks about what Shelley just discussed about the need for mainline health for those parking spaces.
Yeah, it actually goes, Mr. Ryan, this also goes to the discussion on traffic.
Okay, we'll get to that. Okay.
Yes.
Now, let's show A28, which is actually the proposed plan, or you can look at A31, whatever one you feel comfortable looking at. Perhaps we should use A31. Maybe that's a better plan to show because it is in color. Shelley, I think you already said basically on what the proposal is, but for the record again, could you just describe how many square feet we're talking about constructing?
The building, the proposed building would be 70,200 square feet on 3 floors, with the total height of the building under the 38-foot requirement. There's a connector lobby that would connect the 2 buildings. The connector lobby is about 2,700 square feet. And there's a covered walkway that goes from an elevator and a stairwell in the garage, and a covered walkway going from the other side of the garage, another staircase.
And Shelley, we do have a structural engineer here, and you have a letter in front of you from him, but he will also testify. Are there any other alternatives for this site, or possible alternatives? I guess one alternative would be put a 2nd or 3rd story on the existing building, correct?
Yes, the footprint on the current building is approximately 66,500 square feet. If we wanted to build, if we had the ability to build, if it was feasible, we would build a 3-story building on this footprint, which would take us to just under 200,000 square feet. The other option would be, in combination with the 252 property, we could actually build a building that would be approximately 215,500 square feet in the same footprint, in the same PB area. And if we just decided to raise the current existing structure and just changed it over to a new building.
Okay, and I'm going to show you what's been marked as A29. I believe this shows the buffer. And if you can, why don't you describe what you're doing regarding the buffer and discussions you've had with the neighbors?
We are, as part of the plan, we're planting 47 20 to 25 foot tall Norway spruce trees along the property line. And these spruce trees are anywhere from 10 to 15 foot in diameter. And as you can see, they are overlapping so that they create a screening of the adjacent residential community from the building. The residential community, if you look, you'll see the elevation on 14 Radnor Way is at 120 feet. The building is going to be at 104 feet. when we take the 120 feet and we add 25 feet of screening and plantings, it will actually screen the entire property, the whole western view from the residential community on the eastern side of the property line.
Is there any difference in the landscaping plan from what was presented a couple months ago?
There's some supplemental additions to that landscaping plan. We are going to, one of the residents who actually sits a little bit higher and a little further away, we are adding some additional screening to their property line so that when they're looking out of their house, they'll be looking at additional screening. And Radnor Circle, we're going to enhance for the community, the benefit of the community, we're going to enhance Radnor Circle. It's now not very well maintained, so we've gotten permission from the 3 residents that own jointly that circle, and you can see the property lines that go through there. And I'm pointing to it on the plan right now.
On 829.
829, and what we're doing is we're going to deal with the condition that continually gets destroyed by snowplows, cars, vehicles, delivery trucks, and remedy that condition for them.
How far, this plan actually 829 shows it, how far are the existing residences from your proposed new office building?
Actually, this plan shows a little better.
Okay. I'm referring to
yeah,
828 here now.
Yes. If you look at the residents at 14 Radnor Way, which is shown, I'm pointing to on the plan, they are actually 217 feet from the Schifrin Barrowway building, and they're approximately 215 feet from the new office building that we're building. All of the other residents are closer to the existing PLO building than they are to our property line. They're all, for instance, if you look at 10 Radnor Way, that's 333 feet away from our building, the residents. And when you put the buffering in front of their property line, that will actually take their whole western view, which, by the way, there is an existing buffer. So just to clarify something, there's an existing buffer that segregates our properties, then that's the commercial, both the Brandywine properties and our property, from the Radnor Way community. But from November till May, when that buffer loses its leaves, their view is unfettered, and they get to see the lights of Radnor Financial and our property. By putting in these Norway spruces, they're going to have 24/7, 365-day-year buffering or screening from the commercial properties to their west.
And as to the parking, there's a couple other items you said you would do for the neighbors. Could you tell the board what they would be?
Yeah, if there's a picture here, a rendering of the, let me get the example. Okay.
Describe it.
Okay, there's, I was asked, Mr. Martin asked me this question before. The second and third deck, there's about a 100-foot wall that's created on the second and third deck, the parapet wall. And that parapet wall is, on the inside of the parapet wall, we're going to be using parapet lighting to be able to use that as the means of lighting the deck. But on the outside of the wall, we've agreed to come to do a residential-friendly application. It hasn't been finalized and designed, but at the minimum, we're looking at planter boxes with some type of plantings in there that would be facing the community. With that said, we're also have entered into discussions with the team at Brandywine to do some type of screening on the the northern wall that's created from the structure that we're going to be building on the property line. And again, that would be a more, and we haven't finalized that deal, or that arrangement, but we did agree to carry on those discussions while we go through land development and planning to be able to accommodate a view from their properties that would be looking towards our property that would be more appealing than just a parking garage.
And how about for mechanicals and things of that nature?
How
about for mechanicals? I'm sorry.
There was some concern about the ability to put screening on the roof to protect the view of the mechanicals that currently exist. The previous owner did not do that, did not facilitate an understanding that they had with some of the folks at Brandywine. We've actually had a discussion with our structural engineer after we met with the Brandywine team, and there is a screening available that we can place that will screen the current mechanical systems, not only from the building, our building, but we'll also screen the mechanical equipment from all of the neighbors, all of the adjacent properties.
I'll just go into a couple more photos. First, A18, if you can.
This is the existing, this is the view I was telling you that exists from the western view from Radnor Way. And this happens to be what I'm pointing to is the circle that requires some modification, and that we've agreed to, as part of our plan with the neighbors, to be able to modify the circle to be able to make it more appealing, aesthetically appealing.
And A19, that shows proposed buffer.
A19 shows the proposed buffer, the 25-foot Norway spruces.
And again, A20.
This is the same view. This is the view looking east from our property line, and as you can see this happens to be 14 Radnor Way, and as you can see during the winter months, it's pretty clear that that you can see the homes from the property.
And A21.
This is the screening from the 240 Radnor Chester Road property and the eastern view.
A22.
So that's a rendering of what will be.
Yes, it is. I apologize.
22.
A22 is the view of the existing location where the building is going to go. And again, you can see there's parking standards, which you would see normally in a parking arrangement. The asphalt's being removed in many locations here, being replaced by green, and these parking standards are all coming down. There's going to be low-profile lighting on the property.
23.
This is the view that our neighbors from the adjacent Radnor Way see at night, and the lights in the background, as you can see, this is the Radnor Financial Center, and on the lower side is our building, at 240 Radnor Chester Road. This view will change when we put the Norway spruces in.
A24.
This is the view. This is the current ingress and egress.
A24, I'm sorry, Norm, I don't know if you heard what I said.
A24 represents the current ingress and egress from Radnor Chester Road to the property, and as you can see, this is the behind the truck is the subject ramp, and the ramp starts in the R1 area, and then the PB area starts right about here, where I'm pointing on the drawing, and runs up here, and then the building, the parking structure will be behind 30. It'll be 30 foot on this side, on the eastern side, and this is on the western side. It'd be approximately 40 feet.
You mentioned the 30 to 35 for the new garage. Do you have an idea what, I'm looking at A24, what the existing garage is?
I think it's 12, but we have our garage engineer here. Maybe he can answer that question.
Thank you.
And then now a couple conceptuals that we talked about before. First, A25. There's three over there, A25, A26, A27.
A25 is the Radnor Chester Road view of the conceptual drawing, along with the connector lobby, which is behind the parking area. A26 represents the western view from Radnor. It's the east elevation, but it's the view from Radnor Way. And this happens to be a good indication of the conceptual design of the garage. As you can see, what I'm pointing to right now represents the two decks that are going to be above ground. This is a solid wall, and we've agreed with the community that we're putting a solid wall in to protect the community from light passing through and to restrict some of the noise that would be coming from a garage. So the most eastern part of deck 2 and deck 3 would be a solid wall. And that's the wall we're talking about making residentially friendly through either design or including some planter boxes. A27 is actually the elevation as the elevation. This is the existing residential community on Radnor Way. This is the elevation to the building. And when you look at the elevation of Radnor Way and then you take it at 120 feet and the building's at 104, and you take their home at 120 and you add the 25 feet, it takes you up to 145 feet of screening from the property. So actually, they will not see our building.
Mr. Gross, when you were here before, there was, in the prior plan, there was going to be a significant retaining wall constructed between your property and the Radnor Way neighbors. I'm assuming that that is no longer needed or contemplated by the plan.
Well, in actuality, there is a retaining wall. It's a long, and Alex Tweedy can talk a little bit about it. There is a retaining wall, but it's only because of where we're cutting out from 108 down to 104 to be able to put the parking at that level.
But it's not a retaining wall of the magnitude that was in the prior plan?
No, not at this point.
Yeah, you're cutting it out, making the parking lower, actually.
Yes, we're bringing the parking down to, the building is going to be at 104, so the parking is going to be between 104 and 106. The ramp begins at 106 to 107, so it'll be a direct drive into the ramp. So the park, whereas before we were having to put a retaining wall in to be able to protect the community's view, it's not there any longer.
That's all the questions I have for Mr. Gross. Just to let you know where we're going from here. I have Glenn Richardson here from TPD, and he would testify regarding the traffic reports that were submitted. I have Sam DeGenova, who's a structural engineer, to testify regarding the ability of the existing building to hold more than one or two levels.
Thank you.
George, since you've entered your appearance, do you have any questions you'd like to address to this witness?
I do. Just for a clarification with Nick, there's not going to be another witness really to talk about the proposed conditions?
No. Okay. So, yeah, if you want to.
All right, I just have some additional information I would like to check or ask. Mr. Gross, could you tell me the existing gross floor area on the site?
100,420 square feet.
And what's the total proposed?
It's 100,420 plus 70,200 plus 2,700.
And what's that total?
It's 174, approximately.
74. And how many existing parking spaces are there on the property?
491.
And out of that, how many are on the surface of the land as opposed to in a garage?
There's I believe there's 110 upper levels, 116 existing spaces on the deck.
No, I think he said how many are surface.
How many are on the
Well,
surface?
there's 491, so you would subtract 116 from that.
Well, let me state it another way. Are there
491 in total.
Are there spaces that are not in a garage, either on a lower or upper level?
Yes.
How many of those are there?
300 I think 375.
And how many spaces in the garage?
Well, on the garage deck, there's 116.
So that would be, and there's 2 floors, so that would be roughly,
I apologize, just to clarify a point. There's a lower level under the second deck of the garage. It's on the plan that was provided to you.
Okay.
There's a there's surface parking of 231 parking spaces.
okay.
There's underneath the deck, underneath the parking deck, there's 121. And then on the second level of the parking deck, there's 116.
Okay,
And on the ramp, there are 23.
okay.
The total's 491.
And you said the height of the garage is about 12 feet, you think now?
I would defer to either Nave Newell or Tim Haas to.
Okay, we
Sure.
could get a
Yeah,
clarification on that. And it's 2 stories, the garage?
The garage is 2 stories.
2 stories or 2 levels?
There's 2 levels, I apologize, 2 levels.
And what's the setback of the garage from the rear property line?
I believe it's on the real property line, I think it's 0 setback.
0 feet. And now let's move to some of the proposed conditions. How many parking spaces would be not in a garage or under a garage, surface parking spaces?
84 spaces.
And how many spaces in the garage?
In the lower level, it'll be 136. On the second deck would be 116. On the ramp would be 23. The next deck would be 151. The next two decks are 151 each. And then on the roof would be 73.
And so what's the total parking spaces you're proposing?
734.
734.
Which this is all laid out on Exhibit 28, 828. It's all
Okay.
on the table there under
All
parking.
right. I just saw this for the first time, so I see that now. I
So you don't have
apologize.
to take notes. It's all exactly as he
Okay,
said,
thank
right?
you. Thank you for pointing that out. And is the height of the or you mentioned the height of the proposed garage. I won't go over that again. And do you know how you calculated the required parking under the Radnor Township zoning ordinance for this amount of square footage? Did you take the total amount of office buildings, or did you treat each building separately?
I believe each building was treated separately.
Okay. Is that the way that it's accepted in Radnor? Do you know?
From what I understand, it can be accepted that way.
Right. By doing it that way, that would inflate the amount of required parking space over that which would be required if you counted the total amount of office space. Is that correct?
I wouldn't use the term inflate. I would say that
Excuse me, sir. They're not asking for relief with regard to the number of parking spaces. It's really not relevant to what's going on in this
Well,
hearing.
one of our issues is, which we would get to in our comments, we believe they're actually proposing too many parking spaces, was one of the comments of the Planning Commission, which we agree with. We have concerns about traffic, and we think that putting in all of these extra parking spaces, which will be accommodated largely by the variance that you're being asked to grant by allowing the garage to go up with no setback, we think they're over-parking it, and there's a concern that by putting in so many parking spaces, there will be more traffic, and there could be an impact on that. So I'm just trying to put in the record, what is required by the ordinance, and then so that the board and our client could have an idea of how much excess is here, because I think it goes to, A, how big does the parking garage need to be, which is in the setback and affects our client, but mostly the traffic. Cars in parking spaces are traffic. So that's why I believe it is relevant.
So the Field of Dreams theory, if they build it, they will come? Is that what you're saying?
That
The more
is one of the
spaces, the more
theories.
trips.
Yes.
Okay.
just to supplement your previous question, George, we do not have a tenant relationship for the new proposed building, although we believe that there's an opportunity for us. We have to keep them as separate entities because we have a lease in place. As you know, when you have a lease that has a requirement for a predetermined amount of parking spaces, you have to adhere to that lease or be in violation of the lease. And currently, that lease requires 491 spaces. So the supplemental building that we're building has to be treated individually because we don't know what that end use is going to be. And hence, the 491 becomes 734 in total. But if you do the calculation for the 70,000 square foot building on its own and let it stand on its own, we're actually under parking that to code. We have to go to get relief from our current tenant to be able to pick up an extra 25 to 30 spaces so that we'll be in conformance to the code with the new parking.
Okay. So back to what I was saying, by calculating the building separately, that would increase the code requirement. Is that correct?
Well, it doesn't increase the code. It changes what your target is, but it doesn't increase the code requirement. The code requirement is what it is. We already have an existing condition for 491 spaces, and what we're doing is we're adding spaces to accommodate the new building.
But the code requires that an office building, for the first 50,000 square feet of office building, there's a parking requirement of 1 space per 200 square feet, correct?
That's my understanding.
And then for the balance, there's a requirement of 1 space for 300 square feet, correct?
That's my understanding.
So if you look at each building separately, you go heavier on the 1 per 200 requirement than you would otherwise if you amalgamated the total of office space, correct?
If they were to the same building, if we were building on top of the existing building, I understand your point, but these are
Right.
separate buildings.
Code requires a minimum. It doesn't set a maximum limit.
Right, I'm not saying they're violating anything in the
Right.
code. We
That's
think-
what we're here about. We're here
Well,
about.
part of a variance inquiry is whether there's an impact to adjoining property owners in the area. They're asking to put in more parking than is needed under the code. They're putting that, a lot of that, on 2 levels of parking, which has a 0 setback from my client's property line.
You can present traffic evidence in your part of the case
Right.
if you need to do that. But I mean, the issue of the number of spaces being excessive, there's nothing in the code that prevents him from building as many spaces as he
No.
wants, as long as he's not violating impervious coverage limitations.
We don't
and
have a
things like
burden here. We don't have to put on traffic testimony. They-
No, I'm just saying you may, if you
Right.
wish, to oppose this.
Right, they have to convince the board that there's not going to be a negative impact by putting in this project. Part of the project is to put in a lot more parking than is needed. We see that as a traffic concern in an already congested area. We're not opposed to them building the additional office square footage. We're not opposing the building coverage variance for that. We have no issue with that. There's a lot of things about the project we actually like. Jeff DeVonos, who's here from Brandywine, would tell you that Mr. Gross is a new neighbor, and he's been a good neighbor so far. So we're not here to be negative about the project, but there are concerns we have, and it's primarily related to the traffic, which we think is linked to the having the additional spaces and the size and impact of the garage with a 0 setback, which was approved, I think, by variance before. But if I could just move through these questions, I don't think I'll have too many more.
Yeah, I sense halftime break is coming, so let's do what we can.
Okay. Now, just so I understand, there was an existing condition plan, A3. Is that still here?
It's here, just don't know where it is.
It's under?
No, find it. I'll pull it out for you.
Oh.
That's it.
Thanks.
E8.
So this was Exhibit A3,
E8, I believe.
or A8, I'm sorry. Was there an A3?
A3 was,
I thought that's the one I...
This is the existing condition.
A3 is the purchase agreement for the
I'm sorry,
property.
this is fine. This is the one I thought of. I'm just not as familiar with this garage as you are, Mr. Gross, so I apologize. On the existing condition plan, A8, a large bulk of the building is taken up by the ramp, is that correct?
The ramp begins where this cutout is, and this is the existing parking deck ramp at this point, and it's actually shown on the color drawing here.
So A31, this orange dot on the A31 is meant to show the outline of the existing garage. Is that correct?
Not to the full extent. This orange dotted area actually ends at this, the garage actually ends at the beginning of this ramp, which is a faint line there. You can see the cutout in the, where the planning island is, and then the ramp begins right here, just to the western side of the cutout.
Okay. This narrower part of the,
That's the ramp.
that's the ramp
Yes.
between the 2 orange lines.
Yes.
Now, when you build the proposed additional decks, which I understand to be represented in the yellow area,
Well, yes, it'll be, actually, the second deck will be extended over to the PB R1 line, and then the third, fourth deck will mirror that drawing.
so this area, which today is either empty or occupied by a ramp, will have a greater massing to it, the 4 stories.
Actually, the area in orange to the yellow area here, currently this is all impervious, and there's parking in this area. And what we're doing is this parking will remain in place, but the area above the parking, or above this current parking area will then become parking deck 2.
Right. But presently, it's not massing a building, it's just impervious surface on a ground.
This notched out area.
That area,
Yes.
okay. Now, the letter from Mainline Health A30, that says in the second paragraph that Mainline Health is not in a position to make a decision about whether it will expand. Is that correct?
As of right now, yes.
And it says that it would consider it in the next fiscal year, and some factors it will consider are the property specifics.
Yes.
But that suggests there are other factors they'll consider, correct?
I don't know what other factors they will consider. I know that the factors that they will consider for our property.
Right. So you don't know for sure if you're building all of these spaces, you don't know for sure if they'll be the ones to use them.
Well, let's talk about what we're building. We're building spaces to accommodate the new building that's going in on the 70,000 square feet. And that's the additional delta spaces that we're building, less the amount that we need to get relief from Mainline in their lease. This lease continues through well into 2020, beyond 2020. And the parking spaces of 491 is required by lease agreement. So all we're doing now is just talking about the additional delta that we need to accommodate the new building, which is the 70,200 square feet.
Right. I'm not looking at it that way, but I understand your point. So the lease that you have, that could be changed, correct?
Well, I have to get relief from them to be able to get 20 to 30 spaces to be able to cover the code requirement
Right.
for the
I guess
70,000 square feet.
I guess what I'm saying is the 491 that you say are required now under a lease, that could be changed in the future if both parties change that provision. Is that
Well,
true?
The 491 is an existing condition. What we're doing is we're going to add in from 491 to take it up to 734. If you just do the calculation for the requirement on the 70,000 square foot building, the additional parking spaces that are required just for the 70,000 square feet, I think it amounts to 260 or 270 spaces. So we are actually under parking it by the amount of the shortfall that from the 734 to the 491.
Right, but I'm saying that that amount in the lease could be changed by agreement of the parties. You're not necessarily bound in perpetuity to have that much parking there.
I'm
Is that
bound by
correct?
my lease agreement as of today. I don't know what it would take to change that lease
Right.
agreement.
And you said it goes past 2020.
It actually goes to 2030,
Okay, so that's about
15
years.
15 and a half years.
So it's possible that there could be a new user for this site. After you build all this extra parking, there could be a new user for the site, couldn't there?
In 2030?
Whenever they would leave, by whatever reason.
Yeah, I wish I had a crystal ball to tell you. You're in the
Right.
business. Maybe you could tell me what happens.
Yeah, I don't know. That's one of the issues. Isn't it true that if there was another tenant that was to come into this building after it's built, they might want to use all of those spaces every day?
I don't know. I mean, it's all supposition.
That's possible, though, right?
Anything is possible, I suppose.
And does your plan show how many spaces are required under the calculation?
I don't have that handy at this point, but I think it's
628.
628 is the total amount required, but 253 is what we're providing, and 278 is what's
Right.
required.
So you're showing on your plan, if you do the separate building approach, 628 required, and you're proposing 734, correct?
Correct. That's for the entire property.
Understood. Oh, I had a question. On A31, this looks like a driveway or something, sort of shaped like a J. It looks like it is over in the residential area.
The R1 area.
What is that?
It's an existing condition that I think is required for access by PICO to the poles that exist on this area. And it's an existing condition that was before Brandywine and we came along, that was there from years and generations before, right, Jeff?
Probably part of that 50-foot lot.
Wherever it came from, we don't know, but it's there.
I think that's all I have at this time.
Can I make one
Thank you.
less than 1 second comment?
Well, you have to be sworn, but this is cross-examination of the
No, it's
witness.
not a comment, just to give you the background. We unfortunately.
You'll have to speak into a microphone, and you'll have to be sworn if you want to say something, but it really is out of order, so make it fast, please.
You solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, nothing but the truth.
I do.
And state your full name.
Jeff Devano, an employee of Brandywine Realty Trust. We appreciate the board's patience. We apologize. The notification that went out from the township went to an office of ours in Texas, which until yesterday, an employee and a tenant in one of our buildings notified us of the process. So Sheldon was kind enough to come to our office today and walk us through the plan. George did not have the benefit of seeing the plan or talking with each other until 7:30 when we got here, and that's part of the reason he went through the questioning that he did. That might seem a little out of line or out of character from the normal process. And so we've been kind of ramping up on this in the last few hours. So we were just trying to get a full understanding of the process, and we appreciated your patience. I just felt like I needed to explain some of the background and some of the questioning, which may have been redundant for those of you who are familiar with it, but we were just unaware of the process until earlier today. So.
Okay, we appreciate your situation. Why did it go to that address? Is that the registered address of the property owner?
No, it was an office we had several years ago in Texas, and Sheldon actually provided because we were trying to figure out where it went to. Our tax bills go to us, but the notifications seem to go to Texas.
Mr. Gross, was the sign posted in advance? Was the property
It was.
posted?
Sheldon took care of all the process that was
Okay, thank
necessary.
you.
We just didn't have information available.
Okay, now, what we'd like to do is, we're past halftime, but we're going to take a halftime break for the obvious reasons, and also because I have a matter I want to consult with our solicitor on before we proceed. I have a question of law I want to discuss with him, and we're going to have a brief executive session after we take care of whatever necessary business we have. So I imagine we'll be somewhere between 10 and 15 minutes. right, everybody's here. John's not here, but he's on his way. Okay, now that we have the benefit of our solicitor's presence, proceed with your case now.
Greg? Since we've been talking about traffic, so might as well get to it.
I do. Yes, Greg Richardson.
And Greg, actually, you testified last time, and it's the same traffic report that we submitted previously, correct? Except with an update, I believe.
That is correct.
Okay. And by whom are you employed?
Traffic planning and design.
And what is your profession?
I am a registered professional engineer, civil engineering, and my profession is I'm a transportation engineer.
And you have been sworn as an expert in transportation issues previously?
Yes, I have.
Now, considering this particular project, and you did prepare a report that's been marked A10 as well as a supplement that's been marked as A11?
Correct.
Okay. And what methodology did you use in preparing the report and reaching conclusions?
The methodology that was utilized was to, much like many traffic studies that are performed for a land use such as this proposed office building, is to make an assessment of the existing conditions by doing traffic counts out in the area at the subject intersections, critical intersections that may be impacted by this development, as well as take a survey of the existing conditions along the roadway itself. We have a unique situation here where this is not a virgin ground. It has an existing use on site, so we would count what's out there existing too. Our firm has been actively involved with the school district and working with Ms. Kaminsky and the township on the design of the school's driveway and the traffic signal. And we, as Ms. Kaminsky had mentioned, we have provided her with some of that traffic data to support the signal installation. That data was utilized in the traffic study also.
Okay, and why don't we talk first about that intersection? Could you describe to the board what is being proposed for the intersection and what will be the applicant's responsibility for it?
Yes, the current layout is Radnor Road is on the eastern side of Radnor Chester Road in approximately about 150 feet south of the existing site driveway.
And so we're referring here, when we refer to plans, it's A28 and then the colored version, which is A31.
Correct.
Okay.
Correct. The proposed access is the existing access that serves the Mainline Health Building today will be closed off and will be relocated to a line directly across from Radnor Road. And as was mentioned previously, that particular intersection, this new four-way intersection, will be signalized. Turning lanes, left turn lanes for both driveways will be provided. There will be a sharing of the cost, at least as was mentioned earlier about the traffic signal. The turn lanes themselves will be put in such that time when the signal is installed. There is additional driveway that serves, I believe, what's the?
252?
252. That driveway will also be closed off. So there will be one means of access to the site directly from Radnor Chester.
And when you mention the turn lanes, what is the effect of the turn lanes?
Well, the effect of the turn lanes are that they will provide a stacking area for the vehicles that are going to be utilizing the driveways, the school district's driveway, as well as the existing and proposed building driveway. What it essentially does is it removes the vehicles from the through traffic and gives them a safe haven, a location where they could sit, and it doesn't impede the through vehicles that are traveling up and down past the site. So this is, I think everyone would agree that this is a huge improvement on what's out there now. The other item to note is that with the offset of the driveways and what we have today is what we call overlapping left turns. It's a movement where it's difficult when they're jockeying for the same space to make that turn into each driveway. So by aligning the driveways, you have a safer and a more efficient design.
Okay, so by these traffic improvements, will it alleviate some of the traffic on Radnor Chester Road?
Well, it will make the driveways themselves safer. We will be adding traffic. I mean, it's a new use. It's a matter of how you manage that new traffic. And by putting in the traffic signal, putting in the turn lanes there at the access points, not only solving an existing deficiency, but we'll be able to accommodate the increase in traffic due to the 70,000 square foot building.
Okay, Amy mentioned something about, I guess, that right turn out lane. Do you know anything about that at this point?
This is a conceptual plan. We had discussions as early or as recent as this morning with our client about what the next steps would be. We are in the process of working with the school district on their driveway. The township is doing the traffic signal design, but we're going to be working with the school district to do their highway occupancy permit for their driveway. Along with that, for Mr. Gross's site, we will be designing the driveway that will align with the school district's driveway. And again, this is only a conceptual design. The next step is to meet with PennDOT, and as part of that meeting, the township staff will be made part of that. It will be a participant in that. And based on whatever PennDOT sees that they need as far as turning radii, the alignment of the intersections, I will commit that you will probably, most likely see 2 lanes coming out. It's just a matter of how that's configured, whether it's configured as shown on Exhibit A, I'm losing the numbers again.
A28?
A28, whether that is the final design, that's to be determined. But again, the next step is to meet with PennDOT. Once we know we're moving forward with the project and moving forward with land development, usually that is the point where we have a scoping meeting. We work out the details, the general alignment of the intersection and the general design of it, and then we make the application at a later date.
And the applicant will be responsible for all the improvements on his side of the street, including the left turn lane, of course, his ingress and egress?
Correct, as well as I believe the township is requiring that the applicant pay for his share of the traffic signal and the equipment that is associated with his particular needs for his driveway.
Okay, so let's talk now about the traffic impact of the proposed building. Have you done, I'm sorry.
A couple of quick questions.
Sure.
The consents and agreements to pay from other landowners, including the school district, are not in place yet, right? They haven't agreed in writing that I will pay for these improvements.
I'm not privy to the agreements. Certainly with Mr. Gross's site, I don't believe that's been worked out because we're in the middle of these hearings here now.
And PennDOT has not approved this and retains its full decision-making rights provided under the law. It hasn't committed to approve this yet.
That's correct. They haven't. They are in the process, as Ms. Kaminsky had mentioned, of reviewing the traffic signal. I do believe there is a third party or fourth party, if you want to consider it, which would be Brandywine Realty, who has contributed toward the cost of the signal also as part of their development of their parcel.
I had another question I'd like to ask you. And that is, we're talking about facilitating the movement of traffic into and out of this site, and as an ancillary matter, into and out of Radnor Road. But we're not talking anything about improvements to the Radnor Chester Road intersection with King of Prussia Road or with Lancaster Avenue, are we?
We are not.
And what is your general opinion of the movements at peak hours at those intersections?
Those intersections are congested. They're highly congested, and we have worked with the different, we've done our traffic studies in being involved with the biomed application with the township, or the new ordinance there. But we are, at this point, we have done a traffic study. We did look at the impacts at those 2 particular intersections, and I'm sure Nick was going to have a question about that, but at the intersection of Radnor Chester and Lancaster, our traffic will increase the delays there by less than 4 seconds during the peak hour, And at the intersection of Radnor, Chester, and King of Prussia, it would be less than 2 seconds. So with that in mind, that
That's
is
for
not.
all movements? For all movements?
For the whole intersection. And that's what when you're looking at the intersection itself, in terms of when we have to go to PennDOT, when they'll review the traffic study, they'll look at that intersection and determine whether, if we have a change in level of service or an increase in delay by more than 10 seconds, then they will require us to mitigate that impact. And that is not the case here. We are not increasing the delay more than 10 seconds.
Well, you're talking about over existing conditions today.
Over conditions, no. What we're looking at is conditions and including any known development that is going to take place in the area, as well as increase in general background growth. So we're just, we add that to the existing conditions, then we add our traffic to it, and you make a comparison of that. So it's basically pre or post construction of the building.
So these extra 100-some cars that you're going to very efficiently move out of this property, they're going to only wait another couple of seconds at either end?
Based on the studies that we do, that's you know, the way we analyze the intersections. 2/3 of the vehicles are going to head toward Route 30, and the other third are going to head toward King of Prussia Road, head to the north.
These studies do assume that these improvements will be installed.
The improvements at the site access? Yes.
Yeah, and remember, too, we're willing to condition any approval on those improvements being installed. So if PennDOT doesn't approve the plan, obviously, we haven't met the condition.
Dick, are you going to take us to A11? Is that what we're going to do?
Yeah, and also, just quickly, Greg, you had mentioned traffic. How much traffic, peak hour traffic, which is how you measure traffic, how much will this site generate?
In the morning, 88 new trips, and in the evening, 83 trips.
And actually, some of those are entering and some of them are exiting trips as well, is that
Yes,
right?
you'll see around 80% of the vehicles, depending on the morning or the evening, around 85% of those vehicles will be entering the site, because again, the general characteristics of an office building is majority of the vehicles arrive in the morning and they leave in the evening.
Yeah, and when you say
in
88,
mass.
we're talking about the 1 hour period between 8 and 9 o'clock in the morning?
That's correct.
And then in the evening, it's between 5 and 6?
Yeah, 1 hour period between 4 and 6. You know,
Okay.
yeah.
All right, and
Well, on this exhibit, these 3 lines that you have for AM and 3 for PM.
that's, we're going to get to that. No, that's
Okay.
the next one.
That's
Yeah,
next.
we're still going through A10 right now. All right, so, and then on the level of service, I believe is that table 1 on page II that we're referring to when you're talked about the projected increase in time?
Yes.
And what does that, so basically, is it accurate to say that a car sitting at the intersection of Radnor, Chester, and Lancaster Avenue would, as a result of this development, would be sitting there an extra 4 seconds?
Well, it would depend on the particular movement, but overall for the intersection, the vehicles that are at that intersection would experience an increase in delay by less than 4 seconds.
Okay, and Radnor, Chester, and King of Prussia
It's
is-
actually Radnor, Chester, and King of Prussia is approximately 1 second.
Okay. Let's look at A11 here. Can you tell the board what A11 represents?
A11 is a comparison, a trip generation comparison of the proposed, and we have 66,000 on here, but it's actually, the building is shown as 70, but the trips stay the same. What we've done is if you read through the first paragraph there, is we've made a comparison. There's 3 different scenarios that we're looking at. One is that if we build the 70,000 square foot building, just as it's shown on the plan before you tonight. The other scenario would be, as Mr. Gross had mentioned to you, that he has the ability to possibly build another 100,000, but build it on top of the existing structure. And then the third scenario would be as if he completely scraped the site and using 252 as in that particular site, he has the ability to build 215 by right, 215,000 square feet by right. So what we're doing, the comparison that we have here is the 3 lines for AM and PM are the particular scenarios. one for 70, one for 102, and one for 115. And the net difference that you see, that's the net additional space, because we are taking into account what's on the 252 site. There is square footage on that particular site too. So there's 4,000 square feet. The net increase of traffic for each scenario is 88 trips, 122, 147, and those are for the 3 different scenarios. And then for the PM peak hour, it's 83 trips, 124 trips, and 140 trips. And the purpose
That assumes a 15% reduction for public transit,
15%, yes.
even though Mainline Health says that there are people who have to go out all the time and they can't take public transit?
It's based on studies that have been conducted,
So
and
we're making assumptions based upon,
we're making assumptions
Normal office
of
buildings.
numbers that have been accepted in the township previously. And basically, it's related to the location of this building and how close it is to the train station. Also the fact that what we're showing here, again, the purpose of this comparison is to what could be built on the site and what we're proposing. And I'll let Nick just, get into what we're going to commit to as far as a condition of the approval, which is the 70,000 square foot commitment, as opposed to building any more than that in the future. But really, we were trying to show what the traffic would be like if, again, it's pretty evident that it would, more traffic, more square footage, you would have more traffic, and that we're committing to less traffic, less square footage.
Regardless of how economically unlikely it would be that the owner would scrape the site, lose a lease that I believe the testimony was continues until 2030, just to take advantage of the additional square feet. I mean, this is interesting, but I don't know how practical it is.
we've had a lot of submissions here that say you really couldn't put more square footage on top of that building without a major project, and so you're kind of playing both ends here.
I have one other.
We could do this. This would
I'm
be
sorry. I have
nice.
one other question. We heard some questioning a bit earlier. Is traffic a function of the number of parking spaces that are on a property, regardless of whether it complies with code, over code, or whatever? Is it truly the field of dreams effect that if you build the parking spaces, the traffic will appear?
I will say no. You do not generate traffic based on the number of parking spots for a site. And the reason for that is when you design, and any good planner, when he designs a site, and any good ordinance, when they set up an ordinance, is that you have surplus built into it. And in my field, in transportation field, we like to design for at least 15 to 20% surplus to take care of certain circumstances, such as overflow parking. You might have a party at an office or something like that, or you bring staff in from another office for a special meeting. But you do not design it based on that. You base your traffic is based on your square footage, and that's how planners, transportation planners, land planners, that's how we design the traffic around that. And what the studies, every study that you do for an office building is going to be based on the square footage and not the number of parking
Again,
spots.
it's industry standard, but the truth is, some tenants have a higher parking requirement than others, and having extra spaces means you could do a higher density lease, which would result in more trips. So it depends. Some people run what one of my clients used to call a muffin shop, where they have the offices stacked up like muffin tins, and everybody's at desks, and they have a high use, and somebody like that may require more spaces per 1,000 square feet than a typical suburban office tenant. So to that extent, it could result in more trips.
It
Who
could,
knows?
and
Who
again,
knows?
that's why you have this, why we like to plan for the surplus.
Quick question back on 810. Do I understand the table 1 on 2 little I to essentially say that at the intersection of Radnor, Chester, and Lancaster Avenue, your base case PM is that your projection is that you move from a current service level E to a service level of F?
That's actually a typo. That's supposed to be an F for the 109. I apologize for that.
Okay.
I had corrected it in
And
mine.
are those numbers intended to indicate the estimated number of seconds to get through the intersection?
It is the overall delay of all the approaches. Some approaches might have less delay, But the overall intersection delay is, it's accumulation or an average
Okay.
at
Thank
the
you.
intersection.
Thank you.
I have nothing further, Greg.
George, do you have any questions for this witness?
Just a couple,
You said you did.
I couldn't help it. Greg,
Just
and I-
one quick second, I'm trying to, what is the table that we just corrected?
It is in the executive summary, it's on page II, 2I.
Two.
And it's table Roman numeral 1.
Hold on, okay, let me just.
And it says, it's entitled Overall Intersection.
Okay, which one did we fix?
The column, second column to the right, where it says E 109.6.
Yep.
That should be an F instead of the E.
Okay.
That's a typographical error, and I apologize for that.
Greg, and I haven't seen this report, so if I'm going over stuff that's in front of you, I apologize. Greg, the nearest other intersections besides the on-site intersection, what are the levels of service existing at those intersections? I guess that would be first Radnor Chester Road and Lancaster Avenue.
Radnor Chester existing is F, and for during both peak hours, overall levels of service. So the level of service doesn't change, but the delay changes.
And what's the other nearest intersection is Radnor Chester King of Prussia?
Yes, that is level service E in the morning and a C in the evening.
Okay. And what's going down King of Prussia Road, King of Prussia and Matson Ford, what's the level of service on that?
That was not part of our scope.
Okay. How about King of Prussia and Route 30?
Was not part of our scope.
Okay. And F means basically failing, is that correct?
Yes.
And E means it's at capacity and really can't take any more?
Well, it's deemed to be poor levels of service, but it's not at capacity.
Okay. You said you accounted for future developments, and did that also account for future background growth of traffic?
Yes.
And what future developments were you considering in that?
We included Biomed and 200 Radnor Chester Road.
And what did you include for Biomed?
We included I'll just read it. It says it has 295,000 square feet occupied. Our understanding that 475 is permitted by right. This is based on our study. Therefore, TPD generated for the additional 180, so 475 total.
So you didn't account for any traffic that might be associated with, if the zoning changes go through for the PLO district, you didn't account for any additional square footage that could go at Biomed under that?
We did not.
And under that zoning change, Radnor Racket Club and one of the other Brandywine properties next to the train station, are you aware they would be involved in that proposed zoning change?
I am aware, and those properties were not contemplated to change. Only properties that we included were known developments that were not fully utilized,
Right.
not what their future zoning could be. That's not part of our study and not a typical way that we would have done this particular study.
Now, if that zoning amendment goes through along the lines that it's proposed now, there would be a much greater amount of traffic in the area, wouldn't there be?
Just one objection, because right now there is no zoning amendment before the township. There's been discussion, as George and I both clearly know, but there is no zoning amendment before the township at this point.
Well, if the amendment comes back along the lines that it was proposed, there would be a lot more traffic in the area, would there not?
I will say that if you have increased square footage based on those particular sites getting rezoned, then that would translate into increased traffic in the area.
Now, in your study, I assumed you used the ITE, the land use codes for trip generation for this proposed use?
I did.
And what did you use for the existing and proposed facility?
The proposed facility, we use general office building,
And what you use for the existing
traffic counts.
traffic counts? The ITE studies for office buildings, do you know how old they are?
I know they vary back from 1970s up to present, but ITE makes a concerted effort to weed out the older data and make it, if they feel something is not accurate or will skew the data, then they will remove it from the database.
Are you familiar with, there's a trend in office buildings, is there not, to basically squeeze more people in to lesser amount of square foot per person?
I'm not aware of that in my field.
You haven't heard of that?
I'm sure it's possible, but we don't account for it in our traffic studies.
Okay. And have you seen Exhibit A30 from Joanne Magnata at Mainline Health?
I have not.
Could you look at the first page, second to last paragraph there?
Okay.
Does it say what the minimum parking spaces she believes she needs for this use?
Yes, it states the minimum parking capacity that they would require is 730 vehicles.
And I think Mr. Cutler may have touched on this, but this would tend to indicate that they're not expecting transit usage with their use, correct?
I don't know what their use assumes and what their existing transit use is, but we assume 15% for the new building.
Okay. And if they didn't use 15%, then your numbers would be skewed, correct?
Well, for Mainline Health, they are what they are, existing today. So if there's transit built into it, they are the number of vehicles going in and out of the driveway. If they're affected by transit, they are. But for the new building, we assume 15%. If the number goes down, if that percentage is less than 15, yes, it will generate more vehicular traffic.
Okay. And then I know you said this design wasn't final, but I'm looking at the proposed plan. Was there a reason for that? It looks like sort of an odd right out, and it comes very close to the driveway on the adjoining property.
I wasn't involved with that particular design.
Okay, but you'll look at that to make sure that doesn't have a negative impact on the adjoining property?
Certainly, yes. We have to have, PennDOT has minimum requirements for how far driveways can be from adjacent driveways and adjacent property. It looks like we have the adequate separation, but then you have to look at the operation of the particular driveways too. You'll have to go back to what Ms. Kaminsky stated earlier, is that this is not your traditional design, and if PennDOT's already had some comments on it, but if we are going to present this to PennDOT first as the design. If they have other criteria that they wish us to make it a more traditional T intersection without that channelized area, then we'll have to comply to receive our permit.
Okay. And referring back to A30 again, where they say they need 730 vehicles, and the letter talks about conferences and things like that. Did your study look at if a very large number of those vehicles, I don't know what the number would be, 300, 400 vehicles, were attending a conference and they all left at once? Did your study account for any of those possibilities?
No, and the reason for that is that's not a typical condition on the site. It happens, Mr. Gross had testified that it happens roughly 3 times a month, and one would not design a site based on what happens on 3 times a month. You would base it on the normal conditions that happen.
Even if that would occur during one of the peak hours?
No, again, it's much like you don't design for Christmas season traffic. When you're designing an intersection, you design it based on normal conditions.
Okay, that's all I have at this time.
I have one more question. If you can go back to Table 1 on Roman numeral 2 of your report,
Yes, sir.
in the first line, that line of straight Fs there, under existing conditions, it shows 96.1. Now, what is that number?
That is the delay in seconds at the
Right.
intersection.
Now then, the build-out, base and projected, it's going down.
It's because it's assuming you're optimizing the traffic signal timing, meaning the timing with the traffic volumes that we collected today, what's on the permit plan, when we do the analysis, the 96.1 will give you that, that was on the signal plan, the existing signal plan. And then when you do the future analysis, PennDOT allows you to optimize the traffic signal, reallocate the timings to the particular approaches that need it.
So you'll
to
change the
balancing-
timing at Lancaster and Radnor Chester Road
That's what we're proposing, yes.
to allow more traffic to flow out of Radnor Chester Road? And
Not necessarily.
Back up on Lancaster Avenue?
No, not necessarily. We're optimizing the timing at the whole intersection to make the intersection work overall to improve the operations there. And that's basically what you're.
Well,
why
doesn't
they're-
that mean giving them more time to get out of Radnor Chester Road?
Not necessarily, no. It means we could be giving more time. I don't have the numbers in front of me, what we're doing, what we're retiming, but we could be adding more time to a particular left turn movement on Radnor Chester to give it more movement, more time to solve an existing deficiency. But that will all be worked out when your staff if we go to land development, your staff will review this, and if they deem that that's necessary, I know that there's several discussions with several property owners and applicants along that whole corridor about what happens to the signals.
That's part of our problem, is that we have to deal with this now, and all this is in the future and in the hands of other people. And the question is, how much reliance can we put on any of this in making a decision today or next month on this matter? There's so much that's out of our hands here.
I just have a follow-up question. So it goes down in the morning, but it increases in the afternoon?
Again, yeah, because optimization isn't effective in the morning as it is in the evening.
Why not? Just curious.
Because traffic volumes are different, and they come from different approaches on different turning movements. You're not comparing apples to apples here. I mean, you've got most of your traffic in Radnor Chester coming in the morning and in the afternoon. So therefore, you don't give as much time on Radnor Chester in the morning.
Got it.
And again, that would not be affected by this site at all. Everybody's coming in. They're not going out. So the approach, if we took time away from Route 30 or gave it to Radnor Chester, it really wouldn't serve any purpose. So most of the timing that is being redistributed is being done on Route 30.
Actually, the mainline health letter says they're going in and out all day, which is why they don't use mass transit.
Well, all developments have traffic going in and out all day. It's just a matter of the peak hours are
That's
your
one of the
highest
principal
volumes.
things that goes on from this site, according to this letter.
Right, but you don't design for traffic that is happening at midday. You design it where it's highest peak hours, which is in the morning and in the evening. If you can handle the impacts during those two time periods, when you have less traffic volume, those hours will be handled accordingly.
Further questions for this witness? Thank you.
Thank you.
Just, Greg, just a quick follow-up. In your study, have you determined the significance of this development on traffic in the area?
At the subject intersection, yes.
At the subject intersection? And what was your determination?
That the intersections will have an increase in delay, and the greatest increase in delay would be 4 seconds at the intersection of Lancaster and Radnor Chester Road during the PM peak hour.
Do you consider that to be significant?
No.
And whatever happens as far as traffic improvements and things of that nature, you're still talking about a 4-second delay?
That's
max?
correct.
Okay. That's all I have. I would have one more witness, and just Shelley, by a little bit of clarification, because the lease came up again. So if you could just describe what the term of the lease is, and then there's renewal options.
Yes, the basic term of the lease is 2020, and then there's a renewal option that there are 2 5-year renewal options. So to address the issue that you raised, Mr. Riley, it's actually 2020, then 5, and then 5.
Okay. Sam? Yeah, I was going to ask Amy. I know Amy's been sitting here all night, so I don't know if.
I have nothing to add.
Okay, yeah.
Just to know if you needed me to.
Yeah, I was going to say if she wanted to go.
Well, unfortunately, she was never given the opportunity to study the traffic report,
Right,
so we
Well,
really can't.
that's something that happens at land development now. That's the way it works.
So I'm sure you have better things to do.
Yeah.
Leave at will.
Do you have any questions?
No, nothing that anybody else? Nothing to ask you now. Thank you.
Sir, if you raise your right hand. Promise to tell the truth, the whole truth, nothing but the truth.
I do.
State your full name for the record, please,
Salvatore Di Genova.
and spell both names.
Salvatore Digenova.
And Mr. DeGenova, what is your profession?
I am a structural engineer. I am the president of Di Genova Associates. We're a consulting engineering firm providing structural engineering services for the design of new buildings as well as the evaluation and renovation of existing buildings. I'm a registered professional engineer in the Commonwealth of Pennsylvania since 1992.
And were you able to do a structural evaluation of the building at 240 Radnor Chester Road?
I did, yes.
And as a result of that evaluation, you prepared 812, which has been marked and made part of the record?
That's correct.
In particular, what did you analyze in your study?
Well, as part of the study, we reviewed any available drawings of the building that had information on the structural systems. We went and performed a site visit and did a structural survey to obtain any supplemental information on the building framing system, columns, framing, beams, and things that we could assess. And then we did some very general load calculations to determine what the impact of the addition onto the existing structure would be.
Okay, and did you review the possibility of vertical additions to the existing structure?
Yes, we did. There's a section of a two-story vertical expansion and another area of a single-story vertical expansion in an area over the existing addition.
And if you did the vertical expansion, you would maintain the current building coverage on the site?
That is correct.
And did you also do a review of constructing a new building?
No, I did not.
Okay, a review of constructing a three-story building on the site? The feasibility of it?
Well, I mean, if you raise the building, then yes, you can build a new structure in that area, absolutely. Yes.
Okay.
That doesn't really require an analysis.
Right. What was the result of your study regarding the ability of the applicant to construct a vertical expansion on the existing building?
It became very evident that the existing structure has no excess capacity to support this vertical expansion. The gravity loads being the construction framing and then the live loads from additional offices. The existing columns and footings in the air for the building are nowhere near have the ability to support these vertical expansion without major reinforcement or modification.
Okay, and would you be able to do this reinforcement with a tenant in the building?
Very, very, very unlikely. I mean, the scope of the renovations would involve reinforcing every column and footing that supports the vertical expansion, and to do that, that's a major construction effort. I mean, it means new pieces of steel, welding, excavation, new concrete placement, and that can't be done with an existing tenant in there.
So is the vertical expansion of the existing building feasible with the existing tenant in the premises?
In my opinion, no, it's not feasible.
But as you mentioned too, you could scrape the site and build a new three-story building that
Correct.
It would comply with.
And in addition to just the very simple vertical analysis we did, once we add a vertical expansion, by code, the whole building would have to be seismically, retrofitted to accommodate the increased wind and seismic lateral loads. And that's a scope and analysis that's well above what we did at this point. But based on my opinion, that's another area of renovation and modification that is very extensive.
And just the only other item I would like to point out here is that Mainline Health in A30 has stated that they would not agree to a type of vertical expansion while they were a tenant in the building anyway. So I have no further questions.
Just one question. The building itself, though, is structurally sound.
Oh, yes, absolutely, yes.
Anyone else? Thank you.
That's all I would have. I would just request the exhibits be part of the record, please.
Is there any other questions anyone has on the panel? Anyone here in the audience wish to appear and be heard?
Swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your name for the record, please.
Richard Hudak,
And spell.
Richard Hudak. I live at 10 Radnor Way, right there. I want to just come today. I've spoken before about the different various plans that Mr. Gross has brought to your attention. The last time we spoke about our major issue was, in fact, the fact that he was building in the residential area. He has since moved everything away from it. He's also supplemented some of the tree lining with actually some that's going to go on my property as well to cover some of the view that I may see. He has had an ongoing communication with, in particular, the 3 residents that are closest to this property. That includes Robin, who lives here, and also Jim and Sue, who live right here as well. So we are the 3 people that also own the center circle, which he was alluding to earlier. Of the street, we are most impacted, I think, by this, by the view, and also possible construction concerns with noise and that nature. And I don't know if you guys have this document that Sheldon actually signed for us. Do you have a copy for them, Sheldon?
We don't have it, and we were not made aware that any such document existed.
I apologize for that. I didn't draft it, I didn't sign it, so. Do you have copies for everyone, or?
I think he wants to, and we have no objection to it.
Use your mic, Nick.
Yeah, I would just request that I can mark it as A32 or N1, but A32 I think makes sense, and we'll hand it up. It's basically an agreement between Mr. Gross and the neighbors regarding basically what we've talked about already as far as conditions are concerned about buffering and no further expansion and things of that nature.
Was there anything in that agreement that requires something that's not shown on the plan or alters what's shown on the plan?
I don't believe so. I think it's all been testified to. But I will hand it up anyway because I think Shelley said he would hand it up at the hearing. I just
want to make sure it gets into, because it was given to us. I want to make sure that it gets, so you guys can view it as well.
First of all, need the chance to study it and have our solicitor study it before we can take it into account in any decision.
Okay. The one thing that I would like to add to this document that Sheldon wasn't sure how exactly we could do that, there is a confirmation that any trees planted on his property as a buffer, my property as a buffer, or also Robin's property as a buffer will be maintained as long as he's the owner of the property. I know that he has also talked about within the deed, if he builds this 70,000 square foot property or building, that there will be no other buildings put on the property. I assume that goes along with the deed. I think we talked about that at a different meeting. I would like to possibly put into place in the deed of the property that if he sells the property, that owner as well will take care of the trees that are planted.
Yeah,
as
we
a buffer.
really have no jurisdiction over what goes into a deed. We
Okay.
do have jurisdiction over the conditions that the law allows us to place upon approvals that we give.
Yeah, one of the, in my memo, I did mention maintain the plantings as well. I said plan and
But
maintain.
you're saying there are plantings provided for that are off of the subject premises?
That's between
Which
Mr.
is,
Gross and
okay,
me.
so that's something that's not reflected on the plan submitted to us?
I don't believe it's reflected on the plans now.
And I didn't see anything that showed any landscaping off the... Oh, okay. Gave us a new
I'm
landscaping
sorry,
plan.
it's attached to this A32.
But it's not on A29, the revised landscaping plan, right?
It's not on A29.
No.
It is on what I'm handing up now.
This is beyond our ability to read and study now.
I understand, but I did want to bring it to your attention. It's been a long meeting. I don't really want to sit through another one, so I want to give my opinion now, if I can, and on record, please. So I'm not sure exactly how that gets processed, the deed. I know you said you don't have the ability to do that, but I do need to find an answer, I guess, at some point, as far as that goes. But with this being said, what I have given Sheldon is I'm okay with what he's doing there. And that's what I'm telling you, that as long as all these things are followed through the way he explained to us, as neighbors, the closest residential neighbors, that I am backing him with the plans that he has forth. So that's my main purpose.
Mr. Hudak, you referenced two of your neighbors and pointed to their homes on the plan. Could you put on the record their street addresses?
And
yes.
last names?
And their last names?
They're actually on this document.
Please speak into the mic. Anyone will do.
They're actually on this document as well, and on this main document, whichever one, this big one is here.
Just read them.
It's Jai-Jin and, I'm sorry, he goes by Robin.
Okay, go ahead.
I can't pronounce his first name.
Spell it.
Z-H-E.
Okay.
And they're at 14 Radnor Way?
Yeah, I go by Robin. I'm on 14 Runaway.
Yes.
Yeah.
And James D. Campbell and Susan P. Diamond, and they are at actually 254 Radnor Chester Road.
And I think the record should indicate that those individuals are in the room and heard Mr. Hudak's representation that they are supportive of the...
Robin is. Jim, unfortunately, cannot be here tonight.
But one of the owners for each of those properties is here?
No.
No, okay. I'm
This property right here, 254 Radnor Chester, they are not in attendance tonight.
Okay, thank you. So one of the owners of the adjoining properties ratified your statement that they are in support of the project?
Yes, sir.
Yep.
Thank you.
Do you have any other questions for me?
Yeah, actually, the person who just ratified that really ought to be sworn in and formally, and then do that. We shouldn't have a transcript that reflects a nod from the audience.
I will defer to the chairman.
You're up, Robin.
What are we talking about?
We want to swear
Oh,
this
okay, there he
gentleman in
is.
here who's...
I'm sorry.
You're up, Robin.
Robin.
Robin. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
And state your full name, spell.
Please use the microphone, sir.
First name Z-H-E, last name L-I. I also go by name Robin.
And your address, sir?
My address is 14 Runaway.
Okay. And you affirm that you're in support of Mr. Hudak's statements in this letter?
Yes, I do.
And the letter has been entered into the record as Exhibit A32?
Yes, I had a copy. Yeah.
I think that ties it.
Thank you.
Thank you.
Anyone else here in the audience for this? No?
Name is
Sir,
Lee.
you swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
And your full name, please?
Leo Bernabei, Bernabei. I'm Director of Operations with the Radnor Township School Districts, and since I sat here all night, I thought I'd come up and tell you why I'm here. I want to make sure that the driveway as proposed aligns with Raider Road. We're very excited about making that a much safer intersection for staff and students, and we've been working very closely with the township and Mr. Gross to facilitate that. So from what I saw this evening, we're going down the right path. Any questions? Thank you.
Thank you, sir. Well, John, what do you think about memoranda? Do we need anything further?
I am a little bothered by a couple of things. First of all, as I understand the testimony tonight, we would make an approval contingent upon the township, the school district, and other private owners coming to agreement upon and PennDOT approving alternate, some traffic improvements that would alleviate any adverse impact. That bothers me for two reasons. One, this board is supposed to know the facts, and we still don't know exactly what these improvements are going to look like or whether they're even going to happen. PennDOT may come up with a change, somebody else may come up with a change, and so forth, and it becomes a moving target. The second thing is I'm concerned about the board delegating its decision-making authority here. We do occasionally delegate, condition and approval, say, on a stormwater management system being satisfactory to the township engineer, but this is way beyond that. It's, in my view, analogous to saying subject to the designation of a traffic improvement satisfactory to a traffic engineering firm in New Orleans. It's an awfully big delegation, and I would like to know where our authority is to do that much. I think that the board has to make the decision, and I don't think the board is in a position to make a decision with respect to traffic. I also would observe that we've had a lot of discussion about what the applicant has the right to build under existing zoning, but for the existing improvements, but for the lease and so forth, when I think, in my view, the real question is, does the applicant with what's there now have a reasonable use of the property? In other words, if the zoning were such that what was there now is the maximum amount that's allowed, does the ordinance impose a sufficient hardship to justify variance relief? The fact that I am bothered as well by the self-made, to the extent there is hardship, it's because of a lease, which was signed by the prior landowner. But to say we're going to give a variance to let you build back what your predecessor landlord gave away under the lease is to just basically say, well, yeah, your development capacity was contracted away, but we're going to give it back to you by means of a variance. I don't see the variance power appropriately used in that fashion. There is also an issue with the township parcel, which is part of a buffer area. The variance there may be a use variance because it can only be used for buffer, and the area of the buffer going around that little square is a use thing. It's analogous to the Philadelphia zoning code cases, which require that signage be kept a certain distance away from the ultimate right-of-way, and that has been held to not be a dimensional variance, but a use variance based on the way the Philadelphia Code is written. It says you may not put signs there, and therefore to put a sign in that right-of-way has been held to be a dimensional variance. And I recognize are places where Pennsylvania law is not crystal clear on what is a use versus what is a dimensional variance, but in this case, it's an issue that I think very much is in play. I have made my views known that I don't think there's any expansion of a nonconforming use in the back. That parking garage was granted by this board. The approval that was granted was that, and that includes a number of undersized spaces, and I don't see any ability or equity to expand that because of what the zoning, as a non-conforming use. The zoning board granted what it granted. When the zoning board grants an approval, that's all that the zoning board grants. It doesn't grant the next step on the way or an equity towards the next step on the way. These are the concerns I would share with the board. I don't know if the board would want to give the parties an opportunity for a memo of law, and I cannot digest this, the propriety of this document at this time. This requires me to sit down to see if these are appropriate zoning conditions, and I'd have to sit down with it for a while and do a proper job, and we're running out of time. Those are my thoughts, Mr. Chairman.
Nick, would you like the opportunity to
please
give us a further memorandum?
I can address it now. You have my memorandum. The one thing on the condition, relief is always conditioned upon some sort of approval. It is very common for relief to be conditioned upon PennDOT approval of certain items, such as what we're asking for in this case. That is not unusual, and it happens all the time. I'm not really certain of John's comments regarding the buffer area and being a use variance because it is an area zoned residential. I don't think anyone's going to say that you can't plant trees in a residential area, that you need a use variance in order to plant trees in a residential area. So there are a couple of the issues that I have. I mean, certainly I can try to update my memorandum based on the testimony that was presented here this evening, but it's going to be pretty much the same memorandum, to be perfectly honest, if everyone's had a chance to review it. And, I talked about Hurstberg in that, and everyone always said you can't have an economic hardship, but Hurstberg stands for the premise that you can talk about feasibility. And this instance, we have a split zoning district. We have a situation where we could, if it was structurally sound, to build a second or third floor on this building. We're asking just the opposite of that. We're asking to build a smaller building adjacent to it that basically violates the building coverage requirement. And that's the main gist of what we're asking for here, is the building coverage analysis and to ask for relief on the building coverage analysis. As to the existing parking structure, we talked about this earlier in the evening. It's an existing structure. Relief was granted. It is true. The relief does not specify why it was granted or anything of that nature, and all we're asking for is to continue basically an existing condition and not violating any other dimensional requirements of the code. Again, if the board wishes a memo, I don't know if George wishes to provide a memo or not, but again, my memo is going to be pretty similar to what I've already provided here.
I guess, Mr. Cornelia, I would be very much interested. I am well aware that conditions are put in for approval of the stormwater management by the township engineer, approval from PennDOT for this intersection or this entrance ramp. But we're going beyond that. We need sign-offs from a number of entities and owners, plus PennDOT, and we don't know, and to give you what the applicant, what they want, assuming the board would do that for other reasons, requires us to punt the discretion and not know what we're actually going to approve. It's just sort of go on out there and work it all out. I do think the fundamental question on hardship, and I personally don't see the threshold having been met even under Hertzberg and Tolkish, is do they have does this property have a reasonable use? Obviously, most properties would be more valuable if you could increase the square footage or intensity or whatever of the use. But to me, the question is, assuming that you were maxed out right now under existing zoning, not that there was this capacity alleged for doing more, assuming you were maxed out, have you got a hardship? There are constraints that are imposed on this property by the existing lease, but those are not imposed by the zoning. Those are imposed by a lease that was put on by the predecessor as a private contract, and I think that's the epitome of a self-created hardship. And we don't even know if it's totally a hardship. Presumably, there was a reason for entering into this lease, and it's of economic benefit. And I'm also, if everybody is convinced that these traffic improvements are going to be imposed and constructed but by the end of the summer, then we could at least address that issue in an approval in September. I just am bothered. I'm bothered by this Russian. Look, I've dealt with PennDOT before too, and everybody's hopes that it'll get done quickly can pale into bureaucratic malaise very quickly. So,
but the effect is,
Mr. Chairman, I note that none of the board members to this point have offered a motion either to deny or grant the relief that is sought. And I heard a lot tonight, which I found interesting and somewhat persuasive in contrast to the case of a couple months ago. But we did receive the letter that was handed up by the neighbors. Our council has raised some interesting questions I think are worthy of further consideration. I think that I would suggest that we consider opening up a time specific for council to submit anything else in writing on some of these points that they want to bring to our attention, and have a determination made in the near term, but not tonight.
yeah, I think John, you probably have another 30 days anyway, I would think, because you have 60 days and we're probably only.
But can I interrupt this line of thinking
If
for a
that's what we're
second?
gonna do.
Because you said that the line of trees is a buffer anyway. I just realized your new landscape plan shows this line of trees going right through the township's property.
Right.
It doesn't go around it.
If it's not permitted, obviously would have to be accommodated on the other side.
But there's no place to accommodate it on the other side. Because you're asking us to eliminate the buffer zone, and you have paving that goes right up to it.
We've already entered into discussions with Robin, who owns 14 Radnor Way, that if it became more feasible to put it on his side of the property line, they would accommodate us as long as we were entering into an agreement with them to be able to put the buffer in. So if in that 50 by 50 area, if we could not put it continue that buffer, we could move those to that.
So this revised plan, this new version, is something you really can't do. You don't have the right to do it.
You say we don't have the right. There's a buffer there already.
But I mean, you haven't gotten permission from the township to plant these trees.
We have sought that permission from the
But you don't
township.
have it.
They have not provided us the response because they were asking for something in writing from the township for that. But it can't. The buffer still can go in. It would just be moved to the eastern side of the property line.
Before you finish, could we sum up our concerns at some point too, if you're going to finish?
Go ahead, George, take your shot.
We'll be brief. Jeff is going to do most of it, but if the board were inclined to grant approval here, we would ask for some additional conditions to be considered. And we've talked to Mr. Gross about some of these. We think it's important that there be screening on our side of the garage, and Brandywine wants to speak to their tenants about that. We think it's important that the mechanical equipment...
Is there a place to do that?
It would have to be on the wall of the garage, I believe.
because there's a 0 setback. They'd have to do something on the wall of the garage.
What, like the Hanging Gardens of Babylon?
Well, you could do something like a scrim or something that just mitigates the visual impact of the structure.
Is that a solid wall along their line, or is that open?
It's an open. It's a parapet wall that's 3 foot in height along their side of the line. And what we've already done is we've looked at we've had our architects looking at a grid system that you hang on the wall, as Mr. Riley just suggested, and you can supplement that with ivy plantings along the grid system to create a planting buffer. And it was preferable to do that than to put plants along the Brandywine.
Because it looks like you have paving going right up to the property line. and-
May I suggest something as kind of on the lines that Mr. Martin stated? George obviously wants to put the conditions in, but I suggest that we continue to next month. I'll submit a new memo. If George wants to submit a memo by that period of time, that would be fine also. And we can firm up these conditions among the neighbors, among the applicant, among Brandywine, and perhaps come in with something more definitive as far as possible conditions if the board deems fit to approve the plan.
Does that abrogate your need to give us more information now?
I think it would.
Okay.
We can hopefully talk to the applicant, and when we come back next time, hopefully we'll have
And are you going to want to submit a
list.
memorandum on any of these legal issues, George?
I'm not sure if I need
Well,
to.
let's just say that if you want to, we're going to want to have it.
If I
at least
did,
10
tell me
days.
what the deadline would be.
John, 10 days before?
10 days, I could even do 7 days.
Well, don't forget, it's got to get to the township, and, well, I guess
Oh,
you could
that's right,
send it.
doesn't, well, you can circulate it to me directly,
Yeah.
can't you?
I could email it to you.
Yeah,
So whatever further memoranda you want to file, Nick or you, George, just get it to us by the time.
What's the next date?
It's 17th of
Thursday, the
July.
17th, so what would the Thursday before the 17th be, the 10th?
That's what it is. I guess so.
So July 10th for any memos.
Yeah, close of business by email on July 10.
Okay.
And simultaneous submission and all of that.
What's that?
Close the business 11 p.m. for a turn.
Do we get?
Midnight.
And we'd really like to know by then if you do or do not have permission to put that buffer somewhere.
We're going to have to.
Now, we're talking about the physical buffer. We're not talking about the code requirement for the buffer strip. The requirement for the buffer strip, like, we tend to think that's a use variance you're asking for there. But it'd be good to know where you're actually going to put the plants.
One thing, Mr. Chairman, we have to confirm that you grant us an extension of time to continue the hearing until July 17, and an extension of the time to render the decision till after that date, to run from that date.
So granted.
And George, you are consenting to that, yes?
Yes.
Thank you. Okay, well, then the matter of appeal number 2916 is continued to our next meeting. Now, we're going to stop at 11:30. If the next case wants to proceed and be interrupted in the middle, that's your choice. Or we could put you on first next time. Is anyone here on behalf of the next applicant?
Yeah, we are.
Oh, that's right, it's you, Nick. I think things would go a lot more smoothly, Nick, if we did it at one time, but it's your choice. And we could take them first next time. Yes, so they can...
We managed to avoid deciding almost all.
What did I do?
No, I said we managed to avoid deciding almost everything.
I thought they said they were going to stop at 11. Was it 11:30?
It was 11:30.
I wanted it to be 11.
Remember, if it was Charlie, he'd make us go. He wouldn't stop.
Oh, my gosh, yeah.
And remember, Norma, about 10 years ago, we had those hearings that were going till 1:30 in the morning and 2 in the morning, and it was a good thing that we put a stop to
It
that.
used to be really common with the PRDs, like 20 years ago, 25 years ago. I used to work in Chester County, and we'd go out to all the districts out there at the township.
The chair is about to make a decision.
They would all go till 2 o'clock in the morning, all the time. Because you're not there.
No, that's a good way to make a mistake.
There were prior boards that I got out of here at 4:30 in the morning, just want to let you know.
Yes, but
I'm kidding.
we are a very civilized board.
Okay. Yeah, we'll agree to, move it to next month.
Can you give us the
I don't think we need do we even need it? Yeah, I'll give you an
Yes.
extension, but
Yeah,
I
I
don't even know
think
if
we need it
it.
because we haven't actually opened the thing. I think you need to give us an extension on the
Okay,
record.
fine. And I just request that the $200 fee could be waived, the continuance fee.
I don't think we have the power to do that. You'll have to talk to the township staff. That's not
Sue
within our
Jones,
power.
well, she didn't give me.
I didn't even know what the fee
Anyway.
was. I thought it was 150, so
Yeah,
that
it's
shows what I
200 now,
know.
I think. Because it's not really, I guess, all right. I don't think, if you guys don't push it, I don't think township staff's going to push us paying another.
If your client's not happy with it, let them blame their lawyer who just took up all the time on the other case.
Okay.
I'm just joking.
So will this be listed before the Brandywine and? Yeah.
I think if you'd request that, it would only be fair to put you ahead of them next
Okay,
time.
fine, because I don't think we're going to be
You had to
that
sit
long.
through their presentation, they may as well sit through yours, you know.
Okay.
Of course, if we have some homeowner with a 15-minute case, we don't know. what
Yeah, I
to do
know,
there.
yeah.
That's all pending. The chair has a little discretion on those things.
Okay. All right, thanks. All right, thank you.
Thank you. Good night. Meeting is adjourned.